We're recording now.
All right. Welcome everyone to the full Board of Trustees meeting agenda. My name is Brandon Stallings, Chair of the Board of Trustees. And as a reminder, just to our trustees and to the members of the public, this meeting is being recorded. I'd like to start things off by having our Board Secretary, Luis Arapetian, take roll call.
Barahona.
Aye. Sorry, present.
Thank you. Buenaventura.
Present.
Chen, not present. Cisneros.
Here.
Good.
Here.
Huser.
Here.
Shelby.
Present.
Soel.
Present.
Stallings.
Present.
Stevens. Stevens.
Present.
Thank you. Tony.
Present.
Trejo.
Present.
You have a quorum, Chair.
All right. Thank you and welcome again to everybody. We're going to go to public comments, but before we begin public comment, I wanted to alert the board and the public that item 60-2 relating to a filing fee increase for the mandatory fee arbitration program will be discussion only. After the staff report for this item was posted, we received some feedback expressing concern about the potential unintended consequences of this change on local bar association fee arbitration programs. We will hold a discussion today, and staff will come back to the board with a recommendation in July after holding stakeholder conversations with local bar associations. So we will not have that item on for a vote today. In addition, agenda item 701 is being withdrawn from the agenda because given the important import of the issues, I really think it's important to finalize key terms before bringing it to the board. We will likely need to hold a special set meeting to approve this contract. So just be on the lookout for emails from Ms. Arpetian scheduling that, but did want to inform members of the public who I'm sure are going to make comment that we are withdrawing 701 at this time. Regarding public comment, State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool. For those of you who are participating via Zoom, you should have that function for virtually raising your hand. It's the hand icon. It should appear at the bottom center of your screen. If you wish to address the board, please click on the hand icon now. And doing so will alert State Bar staff of your intent. They'll call on you in the order that the hands are raised. For those of you who are participating via phone, you may virtually raise your hand by pressing *9. That is the star key, the number 9. Again, doing so will alert staff that you'd like to make comment, and State Bar staff will call on you and open your microphone so you can address the board. For those of you participating via a notice location, please alert State Bar staff present in the room that you would like to make comment. Due to time restrictions, we cannot allow more than 3 minutes for each speaker. Please note that staff will have an on-screen countdown timer visible to all attendees during the duration of your public comment. The timer's 3-minute countdown will begin as soon as you start your comment. The on-screen timer will flash for the final 10 seconds. Looks like we have 2 individuals who have signed up ahead of time, so appreciate you doing that. First individual I'll call on is Benjamin Cohn.
Hello again. I wasn't aware that when I spoke previously, it was not to the full board for public comment. So I just want to briefly repeat the first 2 points, which was that I support the proposal for a new vendor. I believe it will enhance operational integrity and that it will provide remedies both that are not available under the NCBE as far as exams on different dates, makeup exams for operational things that go wrong, that always happens. It's a different thing each time, as well as for certain policies concerning testing accommodations. Next, I wanted to address that the legislature, and especially the Assembly Judiciary Committee, which recently had a hearing, doesn't seem to be inclined to grant the State Bar its full requested fee increase. in part because it disagrees with some of the state bar's behavior and policy decisions and is not wanting to fund conduct that it doesn't like. That was expressed. I testified at the hearing. Some of you were there, and since then, I understand that there's been some pushback to a few things they've asked for, and that is puzzling to me because it doesn't seem to be conducive to getting the full fee increase considered if they're even open to it at this point at all, which is dubious. But hopefully you'll be able to at least support the things that they ask for as a negotiation for that, and especially the things that I'm lobbying for. Thirdly, I wanted to address that 6 months ago, you voted to approve the testing accommodation rule revision. I disagree with the substance of what you voted to move for, but that's now, I guess, a matter for the California Supreme Court, since you rejected our suggestions. Unfortunately, you haven't moved that proposal to the court to allow the court to have that consideration, even though it's been 6 months. Initially, I was happy and even requesting a little bit of additional time because I was granted leave to file a responsive brief for a client. But it's getting to the point now where at 6 months, it's if it keeps not happening, it's a year of exams that happen without any rules change whatsoever. And that's prejudicing disabled applicants with that delay. The court is not given an opportunity to provide them any relief on now 2 exam cycles. I don't want that to stretch into a third. So I urge you to be, whatever is going on with that, to make it a higher priority and get that before the court so we can respond.
All right, thank you, Mr. Cohn. Next up, we have Maria Grijalva.
I do not see that Maria has her hand raised. Okay. I do see Maria in attendance, so we'll go ahead and enable their mic. Maria,
Ms.
you're.
Grijalva,
Yeah.
Ms. Grijalva, did you wish to address the full board? Okay, it looks like we might be having some technical issues, so we'll circle back with Ms. Grijalva. Now, Secretary, are there any other individuals who wish to address the board?
Yes, we have Todd Hill.
Thank you for the opportunity to speak. Ladies and gentlemen of the Board of Trustees, my name is Todd Hill. As someone who has encountered significant transparency issues with the State Bar, I'm here to emphasize the urgent need for reform within this esteemed organization. Today, I present detailed concerns in the document submitted for this meeting, entitled A Hidden Ledger, Public Comments on Reforms for State Bar Closed Session Transparency and GAAP Compliance. Specifically, the closed sessions in questions are closed to discuss liabilities and exposures that remain unnamed and conspicuously absent from the State Bar's official accounting records. Whether these liabilities materialize or not, the lack of transparent reporting makes it impossible for the public to effectively monitor or verify whether the closed sessions were justified or their outcomes accurately represented. In any case, the omission from the financial statements strongly indicates that the agendized items do not satisfy the stringent criteria set forth under the Bagley-Clean Act and Government Code Section 11126 for inclusion in closed sessions. Transparency is not a mere preference in the pursuit of justice. It is an absolute imperative. The integrity of the State Bar must be beyond reproach, beginning with how you manage your closed sessions. The concealment of liabilities undermines your adherence to generally accepted accounting principles and severely erodes public trust in your institution. True transparency means accountability, principle robustly highlighted in the document I submitted. It is imperative that you align your practices with the most stringent transparency standards, transforming your hidden ledger into a transparent testament to your commitment to integrity. As guardians of the legal profession, you bear the responsibility not just to protect ethical behavior, but to embody the very essence of it. Your discussions, currently obscured behind closed sessions, are laden with significant public expectations. practice of relegating substantial fiscal liabilities to the shadows not only compromises your compliance with GAAP, but also casts a long shadow over your institutional credibility. It is critical that you overhaul your closed session protocols to meet rigorous transparency standards, thereby fostering an environment where public confidence in your operations is absolute. Thank you for considering this commentary. I look forward to witnessing your decisive action in making the State Bar a model of transparency and accountability. I cede the remainder of my time.
All right, thank you, Mr. Hill. Who's next?
Next, we have Ray Hayden.
Hello, everybody. I want to hit the bottom part up top here. Okay, so an additional bottom line up top, all of those placed in a provisionally licensed lawyer program, limbo, ought to be directly admitted to the practice of law so long as they admit all of the other admission requirements. This is based on the amount of time they've been practicing law as a provisionally licensed lawyer and the pain and suffering they're going through in that little bubble of the pandemic. I would request that CalBar staff and the committee seek to aid in this solution to a problem and directly admit those who have performed well in the PAL program. You can come up with your own whatevers, but I mean, those people have paid the price. I am not one of them, but they paid the price for that. Now, the bottom line up front on the California bar exam, even though it's been pushed off, I do want to address this here. The California bar exam should only consist of objectively scored multiple choice questions, which must be honestly objective and also fair. This would not trigger the 2-year rule because the exam would still test required points of knowledge. As an example, the FAA has never given me a long answer written assignment, only multiple choice questions. And there are a lot of pilots out here who have each passed a number of these exams. My upcoming commercial drone pilot recurrent exam, which I must take every 2 years, is only multiple choice, and it also requires a score of 100% perfection to pass. The high failure rate on a California bar exam is not mathematically justifiable because California, like all jurisdictions, dictates what we must study and how we study it. As of all of us have been successful graduates of our programs, and there is a plethora of material available to prepare for the exam, it is simply not feasible to justify the failure rate. Analysis of exams from the 1440 cut score realm clearly indicate that the scores given individual item terms on the written section of the exam are actually awarding failing scores most of the time. I have previously submitted an image from the actual official CalBar report showing this fact. Even I provide free materials to those seeking to pass the exam, and there are currently admitted attorneys in California who have in part passed using what I call my definition sheets. Thank you very much. I hope you have a great meeting, and I look forward to, if CalBar is interested to talk to me about it or whatever, I can demonstrate to you multiple ways to save much, much more money and keep your exam, but there's more discussion going on that. But anyways, to keep the exam right, tight, and out of sight, and it would be actually, honestly, objective and fair. We're newly licensed lawyers, and we can be better than minimally competent, which I and everyone should find to be insulting. All right, so other than that, have a great meeting, and thank you for your time.
Thank you, Mr. Hayden. Who's next?
Next, we have Claire.
Good morning. I am aware that item 701 has been tabled, but I have several comments that I think are important and still relevant that I'd like to share. I submitted written public comment earlier, but did not meet the timeline, and so that's why I'm taking time today to speak, and I appreciate your patience. In terms of moving to an independent set of multiple choice questions, I, like Professor Deborah Merritt, believe that this is a move in the right direction. However, I also agree with Deborah Merritt in terms of this not being something that should be led exclusively by the State Bar's financial situation, that multiple choice questions alone do not meet the criteria that the BRC outlined in terms of looking for methods of testing for minimum competency that focus more on actual practice of law and avoid the pitfalls that multiple choice questions often have in terms of bias when it comes to race, gender, ethnicity, and disability. I do believe that the State Bar can and should be working on this issue in an integrated manner, along with many of the other reforms that it's considering. In terms of the move to test centers, I also agree that this is a move in a positive direction. Not only will this address some financial issues, but it also most likely will result in a better experience for examinees. The list is exhaustive, and you'll see it in my written comment in terms of the positive outcomes, but I want to highlight a few that are important to consider. Going to a fully remote or even a hybrid remote situation resurrects all of the challenges that we had in 2020 and 2021 when the exam was being administered remotely. There also would be inconsistencies in terms of having one population take the exam remotely and another taking it in testing centers. Some of the fears in terms of the inability to meet the capacity using testing centers, I think, are premature, because I think the state bar should and can review what the actual number of July examinees will look like after factoring in considerations such as declining law school enrollment, the impact of California potentially offering a second method of licensure, California law students moving to states that do offer supervised practice licensure, increasing pass rates, which would reduce the number of repeaters, and the potential via use of test centers and a non-national exam for offering the exam more than twice a year, which would be a huge positive move, both for examinees who must repeat the exam, as well as people who have temporary disabilities on the date of the exam. I also want to highlight the fact that looking at alternative licensure, may I have 30 seconds to complete?
Yes.
Thank you. Looking at alternative licensure has now become the norm, not the exception. Recently, the American Bar Association, which is one of the organizations that many of us thought would never look at licensure by supervised practice, is examining this issue, as well as the National Center for State Courts through its CLEAR initiative, which has actually reached out to the ELISA Fund to learn more about our fellowship and other models of supervised practice licensure and trainings. Thank you for your time. I appreciate the work you're doing. And again, I fully believe that the state bar can simultaneously consider all of these different issues, and in fact needs to consider them, because doing so individually results in unintended consequences. Thank you so much.
Thank you. Who's next?
We do not have any additional members of the public wishing to address the board.
All right. We will next go to item 10, which is minutes from our March 21st, 2022 full board agenda. So if any individual on this body believes any corrections or modifications need to be made to the open session minutes, if you could bring it to our attention. And if not, then I'd ask for a first and a second.
Motion to approve.
Was that a Vice Chair Cisneros?
Buenaventura.
Oh, Buenaventura, my apologies. Okay, first by Trustee Buenaventura, and sorry, I thought I heard a second.
This is Cisneros, I'll second.
All right. Vice Chair Cisneros with the second. May I have a roll call vote, please?
Barahona,
Aye.
Buenaventura,
Aye.
Chen, not present, Cisneros,
Aye.
Good,
Aye.
Huser,
Aye.
Shelby,
Aye.
Stevens,
Aye.
Soel,
Aye.
Tony,
Aye.
Trejo,
Aye.
Stallings.
Aye.
11 ayes, 0 nays, minutes are adopted.
All right, thank you. Go next to Chair's report. I wanted to report out to the board that I testified at the Assembly Judiciary Committee hearing on April 30th regarding Assembly Bill 3279 in support as amended. I'm happy to report that AB 3279 passed, excuse me, out of the committee and should soon be taken up by the full assembly. It did pass out, not with the amount that we have requested, and we continue to work with staff and with stakeholders about getting up to that full amount. I want to thank staff for your work in preparing for this hearing, and to the various legislators who have engaged with the state bar and have expressed interest in the work of our organization. I personally continue to work toward a fee bill that adequately funds our core operational needs in a way that meets the growing demands of the public and accounts for trends that we are seeing that relate to a decline in the rate of attorneys who are added to the profession and an increase in lawyers who are going inactive. In order to help make our case that a well-funded bar is a necessity for the profession, staff and board members have set up and participated in town hall meetings with, just to name a few, LA County Bar Association and the California Lawyers Association. And through these meetings, we've had an opportunity to hear directly from licensees regarding their concerns and potential impacts of an increased licensee fee. So as chair, I'll continue to advocate that this body is well funded and that is funded in a way that meets the demands of the legislature and the demands of the public. I also do want to talk briefly about one other issue, and in light of recent student protests happening across the country and multiple inquiries we are receiving here at the state bar regarding the potential impact of these matters on individual moral character applications, I am directing staff to explore this further and bring back recommendations to the board in the appropriate form and consistent with applicable law and state bar rules. Specifically, I have asked that staff research how protest activity has been handled in the moral character determination process historically, consult with members of the Committee of Bar Examiners and subject matter experts on ethics and First Amendment issues, and explore how other jurisdictions are considering whether such protest activity should factor into character and fitness reviews for admission to the bar and licensure as attorneys. This is a complex issue that demands a thorough, impartial, and expeditious review process involving all key organizations governing bar admission. So stay tuned for further work on that. This concludes my report, and we'll next hand it over to Leah Wilson for her Executive Director's report.
Thanks, Chair Stallings. I don't have a report this month other than to emphasize that we are working hard and have been on advancing our fee bill proposal. And I want to share my appreciation for the chair and for all of the board members that have been actively engaged in that process. Thank you.
Absolutely, thank you. We'll go on to item 50, which is our consent agenda. I would note that we had advance notice that agenda item 50-4. This is a report of action taken by Audit Committee on behalf of the Board of Trustees regarding annual financial statement audit, including legal service trust fund report, will be pulled from the consent calendar, and that item 50-5, approval of the 2024 Q1 Board of Management travel expense report, is also requested to be withdrawn. Other than those two items, are there any other items which a member wishes to pull off a consent? All right, seeing none, if I could have a motion and a second as to the remaining consent agenda items, which are 50-1, 50-2, and 50-3.
And
50-6. There you go. Sorry, Trustee Tony, is that what you're going to say?
Yeah, sorry.
Okay, perfect. All right, can I have a motion as to those items?
So moved.
Second.
Okay, first by Trustee Tony, second by Trustee Stevens. Madam Secretary, can I have a roll call vote, please?
Barahona,
Aye.
Buenaventura,
Aye.
Chen, not present, Cisneros,
Aye.
Good,
Aye.
User,
Aye.
Shelby,
Aye.
Stevens,
Aye.
Soel,
Aye.
Tony,
Aye.
Treo,
Aye.
Stallings.
Aye.
11 ayes, 0 nays, motion carries.
All right, we will go to item 50-4. This was a report of action taken by Audit Committee on behalf of Board of Trustees regarding the annual financial statement audit, including the Legal Service Trust Fund report. And this item is being presented by our Chief Financial Officer, Ms. Montoya-Chico. So again, welcome, Ms. Montoya-Chico.
Or Sally.
I think she should be joining. Yes.
Yes, I am here. I wanted to leverage the presentation, if give me a moment, so that I can go through this item quickly. Give me a second. Okay. I'm going to be sharing my screen just to give an overview of the results of the financial statement audit that were presented to the audit committee last week. So I'm going to share my screen. Please let me know once you see it.
All right, I see it.
Yes.
Is it in presentation mode?
Now it is.
Okay. I'm just going to go directly. This is the first slide that I want to present. The audit covered three reports. The first one was the audited financial statements report. The second one was a statement of expenditure of mandatory fees, which was performed in compliance with the Keller standard that basically says that mandatory fees paid by licensees cannot be used for political or ideological activities. And the third report is the Legal Services Trust Fund report, that's also a compliance report, if you will, based on the provisions of the Business and Professions Code that you see listed here. And it basically says that the distribution of IOTA funds have to be to qualify legal services and legal support centers. There was the fourth report, which is a report that an auditor is required to give to the audit committee, and in this case also the Board of Trustees, that basically summarizes the results of the audit, and any recommendations or findings are also listed there. So I wanted to just high level highlight basically our statement of net position, our balance sheet. You'll see total assets, and our total assets are well above where they were last year. This is a comparison of year over year. A lot higher than that, and it's really mainly by the trust account revenues that I've mentioned, even in my quarterly presentations to the Finance Committee and updates to the board. As we get more trust account revenue, obviously there's a lot of cash inflow. So you can see our cash has increased significantly. Our cash and investments has increased significantly. And a lot of that is because of the trust account revenue from the Legal Services Trust Fund. Total liabilities also increased almost by $50 million. A lot of this is really due to a lease liability. So there's a lot of accounting standards that we have to apply to the financial statements. And upon selling the building and leasing it back, we now have a lease liability, a significant lease liability in our books. And then the pension liability, that's purely based on an actuarial analysis that is done annually on our pension liability. Really quick on the statement of revenues, expenses, and changes in net positions, also known as the income statement. Our revenues were $430 million, which is almost about $135 million more than last year. Again, as I've explained, it's a lot of it is driven by really the trust account revenue that you see here is really the main driver. It increased $122 million from last year. And these are all grant related revenues that get mostly passed through to subrecipients. The same thing on the operating expenses, it increased by about 38 million. Obviously, there was additional expenditures in OCTC from additional growth that occurred, as well as grants. As grant revenue increases, you also see an increase in grant expenses. And I'm gonna skip ahead, leverage some of the slides that MGO presented, but the result of our audit was basically an unmodified opinion. And in terms of an audit, that is the opinion that you seek. It's the highest opinion that you can get from any auditor. There were no deficiencies, excuse me, in internal controls. That is something that also the auditors, they don't opine on it, but they do look as part of their test work if there's any internal control deficiencies. And I'm glad to report that this year we really had none. I don't want to take some of this. So in attachment D in the agenda item, that's where the auditors basically recommended, there was a recommendation in there that they noted regarding to assessing our compensated absence analysis. It is something that we acknowledge the recommendation. We will do it next year. Next year, one of the items that are highlighted here is a new standard that is going to be effective for us next year, which is GASB Statement 101 on compensated absences. It's going to require us to reevaluate basically how we report our compensated absences in the financial statements. There were also a couple of deficiencies in internal control from prior year that the auditor every year checks to make sure that we've corrected it. So in the report that the audit committee, that the auditors are presenting to the board, which is attachment D, they've listed those as corrected. They both related to IT related findings. And at least I'm happy to report, and it's again included in the auditor's communication to board. Those have been corrected since prior years. So this year there was only one recommendation, which is normal for auditors to provide recommendations, but there were no findings this year, and our prior year findings were corrected for the current year. And I think that is all I will share on the financial statement overview. Mark, I don't know if you had anything you wanted to share.
If I may, Chair?
Absolutely.
Thank you. Thank you very much, Araceli. As chair of the audit committee, I thought it was good to make sure that the entire board reviewed this as part of our fiduciary responsibility and duty. As chair, I was very pleased with the participation of the committee and want to thank everybody, and with the participation of our auditor, MGO. I did want to point out just a few things. As Araceli said, 2 significant deficiency findings for a 2022 audit were corrected. And so they didn't appear on a 2023 audit. And that's significant. And I want to thank Araceli and her staff for those corrections that resulted in a clean audit this year. I also want to point out they looked at something which I had asked for them to do, and they noted that any costs incurred by members of the Board of Trustees that exceed those authorized by the travel, lodging, and per diem meal expense are not reimbursed and are paid for out of pocket by trustees. That's meant to address previous board practices in the past, where there were extravagant amounts paid for with board dinners and meals and liquor, that this is verification that does not happen anymore. Anything over per diem is paid for out of pocket. And so that's clearly stated. The one negative thing that I want the board to know and want the board to track year after year is the pension liability. The current pension liability is, the net pension liability is $81 million, which is about 18% of the, 18% difference between what the liability is and what the funds are for the pension. And that's a number we want to be very careful to make sure it doesn't creep up. We want it to creep down, in fact. And it's important for us to make it clear to policymakers that we cannot fund the operating costs of the state bar. It is not sustainable to do so by increasing the pension liability by not sufficiently funding it. That is not a sustainable position. So those are the comments I just wanted to make. I want the board to be aware of. And that's all I have for now.
Great, thank you, Mr. Tony. Any questions for either staff or Trustee Tony? All right, seeing none, if there's no further discussion, if I could have a first and a second to approve this. Thank you for putting the resolution up on the screen.
I'm happy to move the item.
All right, first by Trustee Tony, do I have a second?
Second.
Second by Trustee Shelby. Madam Secretary, may I have a roll call vote, please?
Barahona,
Aye.
Buenaventura,
Aye.
Chen, not present, Cisneros,
Aye.
Good,
Aye.
Huser,
Aye.
Shelby,
Aye.
Stevens,
Aye.
Soel,
Aye.
Tony,
Aye.
Trejo,
Aye.
Stallings.
Aye.
11 ayes, 0 nays, motion carries.
Thank you, Madam Secretary, and also want to extend a special thanks to Trustee Tony, who chairs the Audit Committee, to all the members of the Audit Committee who have really worked hard and grappled with these issues. Thank you. And Ms. Montoya-Chico, if you could pass on to staff the thanks to the board for working so well, so transparently with the auditors. Certainly as a board member who's been on the board for many years, we've definitely been on the receiving end of some very negative audits, and I'm really encouraged by the positive trends that we're seeing here as we continue to reform our internal practices and continue to be open and transparent with not only the public, but with auditors who are in a position to make recommendations on how we can be even better. So thank you to everyone who's engaged in this important work.
Thank you, Brandon. We'll pass on the thanks to the team.
Appreciate it. We're now going to go to item 60. This is the Board of Trustees sitting as the Regulation and Discipline Committee, and we'll move into that. We're first going to go to agenda item 60-1, which is a report on Office of Chief Trial Counsel 2023 quarter 4 and 2024 quarter 1 performance metrics. This is a presentation only, and it is being presented by our Chief Trial Counsel, George Cardona. So welcome, Mr. Cardona.
Thanks. So if someone could just give me a thumbs up if you can see the slides that I put up. I have a thumbs up. Okay, so I'll just dive right in. So this is our regular presentation on our quarterly statistics. We have the statistics now through the first quarter of 2024, which ended March 30th of 2024. So this is our first page with our key performance indicators. As you can see on the top, most of these are good. So the inventory, the overall pending inventory has decreased, and our caseload clearance rate, that's the comparison of the numbers of cases we closed versus the numbers of cases we'd opened during the period, Our target clearance rate there is 120% to try and make sure that we are working down our backlog of inventory. And that is now at 122%. That's a significant increase over the last quarter, and it indicates that we have done that. We have set a target for this year of trying to reduce our outstanding case inventory by roughly 15%. And with this, we are on track for that, and we'll continue to monitor that throughout the year. The two figures on the right are quality figures. Complaint review unit reopens. That's review of our closures to determine whether they should be reopened when a complainant complains about the closure and seeks to have it reopened. We're at 1% and our target is 2%. That's good. Our random audit reopens, which are openings recommended by the twice a year random audit. They look at 6-month periods at a time. This tends to fluctuate right around 4.3. We're within 0.4% of that. So that, again, I think is right. On the bottom in red, you'll see that our targets relating to time in which we are handling cases are all red. In other words, we are not meeting our targets. Two things here. One, there are increases in the times in the quarter as compared to the previous quarter. And two, we are not meeting our targets. Those targets are based on the new proposed case processing standards. And as part of the April 1st reports, one of those reports was the staffing that was determined to be necessary to meet those targets. If we don't get that staffing in the position, we will likely be adjusting these targets as we move forward to reflect more accurately what we can do with our current staffing. But for now, we've kept those targets in, and as you can see, we're off of all of those. I'll talk about why I think that is in connection with the next slide, or perhaps the slide after that. So it is this slide, which is our backlog slide. And as you can see here, the open cases in backlog, that is open cases that have already exceeded our target backlog standard, increased this quarter. What this suggests, along with the case clearance, the increase in the case clearance rate, is that we've increased our closures, but those closures have been more of the cases that are within the backlog target as opposed to addressing the older cases. So for the balance of the year, one of our focuses is going to be making sure that we are closing not just cases that are coming in as they come in and dealing with those, but also addressing some of our much older cases. We have a number of cases in our inventory that are well outside our backlog targets. And our goal over the next year is to try and address more of those, to try and get this trend line here under percent of open cases in backlog status, which has been trending up ever since Q3 2019, to try and get that turned around and trending down in the opposite direction. Our percentage of cases closed in backlog status, there was a slight increase, but the percentage has remained kind of within this range of anywhere from 12 to 20%, fairly consistently over the last period. Again, we'd like to see that dip down if we can, and we'll focus on trying to get that done over the next 3 quarters and see where we are with our new targets for reducing our inventory. Next sheet is basically a recap of the case inventory and closure. You can see the turnaround in the case closure rate over the last 3 quarters. It's increased and is now up to 122%. Our incoming cases have basically leveled out at close to the pre-pandemic rate, which is roughly in anywhere from 3,900 to 4,200 in any quarter. We're expecting that to remain the same. We haven't seen any trends suggesting that that's going to significantly increase or significantly decrease. So I would expect that the cases coming in are largely going to remain the same. On the right, in the inventory, you can see the turnaround in the curve there as well. The dip down in the inventory, the reduction in inventory in 2024 Q1, which is something we've been focusing on. The case age at closure, you can see a slight increase in both the average and the median in 2024 Q1. I would expect that as we focus on closing out more of our older cases, we'll see this continue to go up as we focus on closing out some of our older cases. That would not be unexpected. Turning to the next page, the case is passing through each phase. You can see in intake in particular, after a dip during the pandemic, it's been coming up back to the level we expect it to come into, the number of cases coming in. We are close to our target of 30 days in terms of getting cases through intake, which is important because that's the first phase. And if cases slow down there, it slows them down throughout the rest of the process. So one of our goals has been to make sure that we stay as close as we can to that target in intake. An investigation, you can see an increase in the number of cases being referred to investigation. That's as a result of, in part, some policy changes that were made in 2022 pertaining particularly to bank reportable actions and client trust accounting cases, where we now send far more of those to investigation. The time for investigation has increased. The time for charging remains outside our target, as I discussed in connection with the first slide. Disciplinary filings, slight uptick in the number of notices of disciplinary charges and the number of attorneys charged, slight downtick in the number of stipulations in the first quarter. Criminal conviction transmittals, we continue to work through and have made significant reductions in the kind of backlog of criminal conviction referrals that we got when the fingerprinting of new attorneys was done in 2019 and 2020. I would expect that this number would remain fairly consistent and potentially drop slightly over the next year as we finish working through that backlog. After discussions with the disciplinary liaisons, one suggestion was that we provide some examples of some of the NDCs so that you could get a sense of the types of cases that we're filing. Some of the areas in particular that we regularly see charges and see cases that we end up filing. One of those is conflicts of interest. This is a case against an attorney who was involved or is alleged to have been involved in concealing the fact that the attorney was actually working with attorneys from the city at the same time that he was purportedly filing a lawsuit against the city for a client that he represented. This is a fairly complex case. There's been a denial of the charges and trial is pending for June 18th of 2024. But this is one of the areas in which we regularly charge cases, conflicts of interest. Another area in which we regularly charge cases is courtroom conduct. This is a stipulation that was done in the fourth quarter of 2023, sorry. That involved an attorney basically in open court conveying what he believed was what he knew was language that actually conveyed a slur against his female opposing counsel. He was unaware that the other side would be aware of what he was doing. The court was unaware of it. This is the type of conduct or conduct like this is something that we regularly look at. In this case, there was a stipulation to a public reproval. Misappropriations of client funds, obviously a focus for us. These are two cases. In one, we filed the notice of disciplinary charges in February of this year. Allegations of misappropriations of somewhere between $78 and $282 million of advance fees that were collected by a debt relief practice group. The charges also include improper employment of a disbarred attorney who is alleged to have played a significant role in what was essentially an advance fee scheme. Trial on this is pending for June 25th, 2024. Another case filed in March of 2024, where an attorney is accused of having misappropriated roughly $4.8 million that were transferred to her client trust account in connection with a divorce proceeding. The respondent in this case pleaded nolo contendere in April. There's a status conference on May 20th, 2024, where we will see how this case proceeds. But this is another area where we regularly file charges. Another area is failures to perform. In one case filed in March of this year, the respondent is charged in two separate cases. In one of those in particular, it's alleged that he failed to file a complaint until after the statute of limitations had run for a slip and fall in a Target store, lied about the date of the event at the complaint, fabricated and submitted to the court a letter from Target purporting to waive and extend the statute, and ultimately moved to dismiss the case after Target discovered the fraud. without telling the client why. In the second, after being retained to represent a client for a DUI, basically failed to do anything and led the client to believe that he'd actually done something. Second case filed in March. Another case of failure to perform, in this case, failure to file a petition for guardianship, failure to file a response to an action to evict the client from trust property, and then again lies to the client by misleading the client into believing that the attorney had actually done something. In this case, there's been a status conference set for May. The information on all these slides is publicly available information. It's in documents that have been filed in state bar court. I will include what should be obvious, but I will make sure it is, which is that these are charges. They have been denied by the attorneys and shouldn't be assumed to be true unless and until proved by clear and convincing evidence in the state bar court proceeding. But that gives a sample of kind of the types of areas in which we are regularly filing NDCs. The last is ones that are based on criminal convictions that we transmit. This is one that was done in the fourth quarter of 2023, a stipulation to disbarment after the respondent was charged in federal court with federal sex trafficking of a minor and persuading an adult to engage in prostitution. After the guilty plea, they were sentenced to 46 months, and then a stipulation was reached in which he agreed to disbarment. So that's some examples of the notices of disciplinary charges and stipulations that we've pursued. This next slide is tracking respondents with multiple complaints. We've fairly consistently seen that for new cases opened, respondents, typically we see 1% with 40 plus, roughly around 5% with 15 plus complaints. So we've been tracking that to try and make sure that we don't see any significant spikes in those numbers or rapid increases in those. We haven't. This seems to be fairly consistent. Next one is our quality controls, referenced on the first page again. Reopens recommended by the complaint review unit, reopens recommended by the random audit, and then Walker petitions denied. You can see that for all of those, we're basically close to or below our targets for those, which is good. In terms of consumer satisfaction, as part of our cases, there's a survey that's issued to complaining witnesses in which they can respond. Over here in terms of, in two general areas, do they feel that they had access, strongly disagree to 1 to 5, with 5 being good and 1 being bad. And then do they feel they were treated fairly, same responses. As you can see, we've kind of fairly consistently been in the range of close to 4 for access and around 3 for fairness. In response to a request from last time, we did some additional analysis to see how average fairness response was affected by the time in which their cases were closed. The hypothesis being in part that if there was more time, one of the hypotheses was that the quicker they were acted on, the more people would be happy about it. But the alternate hypothesis was that the more time that was taken, the more fair they would believe they were treated. That second hypothesis appears to be the case. You can see that as the time for closure increases, the average response on fairness also increases, suggesting that the theory would be that as complaining witnesses believe that their case, more time is taken on their case, they conclude that it's being taken more seriously and believe that they are being treated more fairly, even if that case is ultimately closed. Employee engagement in terms of turnover. You can see that in Q1 of 2024, we did have spikes in our attorney turnover and more particularly in our investigator turnover. We believe that some of this was motivated by individual circumstances, but obviously this is of concern. We'll look at this over the next couple of quarters to see if this is a trend or if it was indeed a kind of one-off spike caused by factors other than satisfaction with employment at OCTC. So that's that. And then there's the glossary. So that's basically the presentation. I'm happy to try and address any questions. And I'll take it down so I can see everybody.
right, thank you, George. See, Trustee Huser has her hand up.
Yeah, just on that last page, if you could put it back up in the spike in
Sure.
removals. Was there also a performance management period around this time, or do we have any performance management statistics that address, how all on the team are performing, and could that have been leading to some of that? And then my second question is, assuming we're not getting a big, huge influx of budget, what is our long-term plan? Is it either to go back and try to get the rules changed on what we're supposed to do in a timely fashion? Or is there some other plan for compliance? Because just quarter after quarter not being able to meet it doesn't seem like a good strategy.
Yeah, so two things. One, on the spike, the way our performance evaluations are done, they're not done at any one particular time during the year. They're based on the anniversary on which the employee started, so they're spread out over the year. So I don't think that the performance evaluations would mesh with this spike in any particular way. We really do think that a number of these were, there were several individuals, there were a couple of people who retired, there were several individuals whose significant others moved to other locations in the country and they moved with them. So we think that these were primarily individually motivated, but again, we will continue to look at this to see if there's some other cause that we can identify. So hopefully that answers the first question. On the second question, in terms of the time standards, the short answer is yes. If we don't get the funding that we requested for the OCTC positions, which were what were identified as necessary to move to our new case processing standards, we'll adjust our targets to be based on the current guidelines or any other different guidelines that the legislature puts in place. So our current guidelines would be 180 days for non-complex cases and 365 days for complex cases. We would adjust and come up with targets based on those for the various timeframes, rather than setting the targets based on what were our proposed new case processing standards. Now, just so you know, in the past, we haven't met those standards either, but we would work towards trying to meet those standards. Does that answer?
Yes, thank you.
All right, I can't tell if anybody else has raised their hand. Anybody else have any questions for George? George, I know one of the things that we presented onto Assembly Judiciary, and that we've provided Assembly Judiciary and Senate Judiciary staff with are materials regarding this project that we want to undertake involving I'm blanking on the term now, but
diversion.
Diversion, there we go. Thank you. Diversion and the impact that diversion would have on on our numbers, especially the backlog. Could you just briefly talk about that?
Sure. So we proposed a series of diversion programs. One that would be in the mandatory fee arbitration area, the creation of a mediation program there to try and encourage some cases that currently come in as complaints that are really fee disputes to instead go to that fee mediation program. The second was a program to be put in place by the public trust liaison, the attorney-client bridge program, which again would be an effort to provide an alternative mechanism for dealing with complaints about failures to return files and failures to communicate through a mechanism where they could call the attorney-client bridge program, essentially have PTL reach out to the attorneys and see if they could solve it without the need to file a disciplinary complaint, again, to funnel some of those cases out. And then finally, within OCTC, an expansion of our pilot diversion program to try and get to the point where we were diverting roughly, we've identified, we think if we do it, we could roughly divert approximately 20% of our disciplinary complaints into a diversion program where they would be closed with certain conditions addressed to the underlying causes of the misconduct, whether it's substance abuse, alcohol abuse, or more commonly, what we see, practice management issues with things addressed to practice management as conditions in return for us closing those complaints without going through the full disciplinary process. Our hope would be that if we put that in place and can identify those cases, it won't eliminate all of the work on those cases, because those cases still have to be processed through the diversion system and identified as appropriate for diversion, but it would reduce the amount of resources that we would have to expend on those cases, and those additional resources would be focused on the more serious cases in an effort to bring down the time of investigation and other things that those more serious cases take. One hope would be that the diversion program would continue to enable us to reduce our outstanding inventory, to bring that down, which would in turn bring down investigator caseloads once we get a lot of that old inventory out of the way, which hopefully would then enable investigators to work cases more quickly. So that's a very brief summary.
Great, appreciate it. Trustee Buenaventura.
Yes, thank you, Mr. Chair. George, or maybe other staff, could you perhaps highlight for us how the legislature or the Supreme Court views of their support for diversionary programs, and what sort of, I don't know, to me, it's been clear that they are very much in support of diversionary programs from the State Bar. Could you just maybe highlight that for us to give us some more clarity on what their views are?
So I think the legislature specifically requested us to do the report, proposing to them recommendations for codifying a diversion program. So I think that indicates some legislative support for the diversion program. My understanding is that the fee bill as drafted includes the resources that we requested for diversion, which I again think suggests legislative support for the diversion program. I have nothing to indicate that the Supreme Court would be adverse to that. Diversion programs are in place in a number of other jurisdictions across the country. A number of other attorney disciplinary systems across the country. And from our point of view, it provides a good way of dealing with some of the more minor violations. To a certain extent, we've already been doing this. A number of our cases resolve with things like warning letters or agreements in lieu of discipline or resource letters, which in effect are forms of diversion. We close with warning letters with conditions. The diversion program would simply formalize that and implement a monitoring system so that we could impose conditions and monitor compliance with those conditions as part of the diversion program.
All right, thank you. Any other questions or comments?
I just had one question.
Yes.
Sorry
Yeah, Trustee Barahona.
Thank you, Chair. George, thank you so much for that information. I have some curiosity around like how this overlays with any IT efficiencies, tools, software that we're thinking about to expedite some kind of the component of this work. And I just have some curiosity on how you all are thinking about that.
Yeah, those are obviously things we are thinking about. We have some things in place already. We use a number of macros and other forms that can generate letters. A lot of time we spend, for example, drafting closing letters to complaining witnesses explaining why we're closing the case. To the extent we can automate that, and potentially if we could work AI into doing some of that, performing the initial drafting, that's something we're looking at. That's one area where we expend a significant amount of resources that potentially could be automated in certain ways. There are other things that we draft that are regular items that we draft. So for example, investigative reports. That's another area where potentially if we could automate some of that or use an AI tool to do an initial draft of that, that's something else that we're looking into. To date, we don't have those tools. We would have to work with a company to develop those tools using a closed system because we can't have our information out there in a way that would be available to be learned by a tool and then transform. So it's going to require some work, but those are things that we are looking at as potential.
Thank you.
All right, thank you. Anything else? All right, seeing none. George, thank you for your presentation. Appreciate it.
Thanks.
Before we go to item 60-2, I am going to go back to a specific public commenter. That's Maria Grijalva. In the interest of her signing up ahead of time and having technical difficulties, I'm going to open it back up for her to make public comments. So, Ms. Grijalva, if I could have her promoted and then activate her microphone.
Thank you so much, Chair Stanley. I'm not familiar with this process, but I do know that after a report is made, the public can usually provide comment. And so I'm really grateful for your time. I wanted to comment in general regarding what George Cardona had just spoken about and what you had just spoken about, and specifically regarding the application of new applicants and moral turpitude. And you know, if an applicant takes part in a protest like January 6th and violates the law, then, you know, that would be very important during the application process. Now, if an applicant takes part in a Black Lives protest, now that is, and it's legal, now that would actually be beneficial to that applicant because they're participating in civic engagement and it's social justice that is being sought. And so there's a big difference there. So if we're going to be putting anything regarding moral turpitude on the application process and review, I think it's important that we break it down in regulations. I noticed that we don't have very clear regulations. I filed a petition with the Office of Administrative Law, my nonprofit has, so that we have clear and transparent regulations. And that's what I'm hoping that we will have in the future, because right now we don't have very clear examples of moral turpitude, of dignity behavior, transparency. So anyway, thank you so much for this moment. And I'm going to learn how to participate because I want to be part of this picture. I'm an important stakeholder. Thank you.
All right, thank you for your comments and for your interest in our work. All right. Going on to item 60-2, as you recall, this is being changed to a discussion-only item, and we have Program Director Melanie Lawrence and Special Counsel Richard Gramme presenting on 60-2. So if we can bring them in, please.
Good morning. It's actually just me today. So this item is designed to implement a recommendation from the state auditor to identify service fees that do not fully cover the costs of programs and consider whether we should implement fee increases on those programs. At the time of that recommendation, the mandatory fee arbitration program was running at about a $210,000 deficit, but we did not recommend a fee increase at that time because the program was going under a redesign process. So I provided more details in the item, but we've completed that process now, and staff has developed a proposed fee increase of 1%. So it was 5% originally of the disputed amount, and we're recommending a 6% fee over the disputed amount with a range of tiers based on the amount in dispute. So that's what we've recommended. In the time, this particular increase would cover the $210,000 deficit that was projected at the time, and that is incorporated into the projected 2025 budget for the State Bar. Because we've had some significant increases in costs, including labor costs and indirect allocations, it would not fully allow us to break even on the program. But to do so would require an 87% increase, and we think that would be opposite of what the statutory intent for this program is, which is to offer a lower cost alternative to fee dispute litigation. And so staff has proposed this particular increase now that would at least allow us to make up the gap from the original projected deficit back in 2022. As Chair Stallings mentioned, we're going to be going back to some local bar associations to understand the potential impact on their programs, and we'll come back to the board in July. But I just thought I would use this time to discuss with the board if anyone has questions about our proposal as it is now, or any comments for us.
All right, thank you, Ms. Gramme. Any questions or comments to help this agenda item move along? Yes, Trustee Tony.
Yeah. So so the point of these fees are program associated with discrete programs is to cover the cost of the programs for administering programs. And so I'm trying to think, what's the rationale of a fee increase that doesn't cover the cost? And what's the rationale of offering a lower cost alternative for dispute resolution if the state bar goes into the hole doing that? I guess it's kind of a big question. I just don't understand. And, maybe the solution is to eliminate the alternative dispute resolution program.
Well, I guess I would jump in and answer that. I think they're really important questions, and I think Trustee Huser has alluded to something similar in asking about the requirements that are placed upon us for discipline case processing, for example, and if in response to the underfunding of our organization that is, for example, reflected in the current fee bill, we should pursue changes to those requirements. So this is a long way of me saying we right now are required to offer mandatory fee arbitration. We could have a discussion about whether or not that makes sense given the nature of the imbalance between cost and revenue. I would say, though, that this is a component of the diversion program that George just spoke to, and that is reflected in our diversion report. And so we do know that we are diverting cases from the discipline system by having this lower cost alternative. So that's an important consideration for us to keep in mind.
Thank you.
With respect to modifying the fee, I just think, to be fair, we probably didn't do as much outreach to the local programs as we should have before putting this item on the agenda, because we had done some work over a year ago. And obviously there's been a lot of other things going on. So I think we just need to go back, have that conversation. I'm not sure how, if at all, it's going to change staff's recommendation, but at least you'll have the benefit of hearing directly from the local programs what their concerns are.
Mm-hmm.
Yes, I don't have anything else to add. I think Leah summed that up.
Great, thank you for that, Leah and Richard. Any other questions, comments? All right, seeing none, and we anticipate having this brought back at the July meeting?
Yes.
Perfect. All right, thank you.
Thanks.
All right, moving on to item 60-3. This is the ad hoc commission on the discipline system, approval of recommendations for website removal and expungement. And this item is being presented by Special Counsel Steve Moawad and Deputy Special Counsel Mia Ellis. So welcome. Great. You all are having a great Thursday, and take us away.
Great, thank you. There's Mia joining. All right, I'm going to go ahead and share my screen. And hopefully you can all see that. So we are here to discuss the proposals to address the ad hoc commission recommendations. And just a brief reminder of how we got here. The board created the Ad hoc Commission on the Discipline System in November of 2020. The Ad hoc Commission and several working groups within the commission met repeatedly between April 2021 and August 2022. The commission made recommendations focused on the effectiveness and fairness of the discipline system. And commission recommendations were sent out for public comment and returned to the board in January of 2023. In September of 2023, there was a very large, somewhat overwhelming agenda item discussing each of the recommendations, which touched on many aspects of the State Bar's work. Following that meeting, we divided up the recommendations by functional area. And so this presentation is about several of the recommendations that focus on the State Bar's regulatory work. So we'll be talking about 4 recommendations today, but we'll primarily focus on 2 related topics: the removal of discipline history from the attorney profile page and expungement. And just to level set the discussion, we've included on the slide here and in the agenda item the timeframes recommended by the Ad hoc Commission for both removal of discipline history and expungement. Their recommendations for those timeframes were the same, and they're on the slide here. At the September 2023 meeting, the board asked staff to revise the removal of discipline history proposal based on recidivism data. And so what we have done throughout this process, all of the appearances before the board with the recommendations, is we have looked at the proposal after reviewing the website display of discipline history policies of other California regulatory agencies, other attorney regulation agencies in other jurisdictions, and now the recidivism data for California attorneys. The recidivism data is presented in the agenda item. The difference between this and the very preliminary recidivism data presented in the September 2023 agenda item is that the prior data was from discipline date to the second offense date. And the problem with that formulation is that the offense date is somewhat inaccurate. Sometimes it's the date the complaint was filed. Sometimes it's a date determined from the narrative of the complaint. But regardless, it is exceedingly difficult to automate relief based on the discipline date to offense date timeframe. The table presented today is discipline date to subsequent discipline date. And so that is a more firm date that we can base the expungement or the removal of discipline history on. So while acknowledging some limitations of the data, including a small population size, particularly for the 2022 people disciplined for the annual discipline report, it appears that Black attorneys in particular would benefit from website removal, with the percent of Black attorneys receiving the relief under this proposal exceeding overall population numbers. And I bring that up because that was one of the focuses of fairness of the Ad hoc Commission. The impact of website removal is even more pronounced when we look only at active attorneys. Black attorneys constitute 5.9% or 6.3%, excluding attorneys with missing race and ethnicity data, of all attorneys eligible for removal of discipline history, as compared to 3.5% of the overall active attorney population. And that's the diversity report card from 2022, and 2.4% of those disciplined in 2022 from the 2023 ADR. The Farkas study is shown in the table as a point of comparison, but I want to note that the population of that study is dissimilar to the population in the table shown for this relief, and therefore really is not a valid comparator. And for example, the Farkas study included attorneys with multiple disciplines, and because of the nature of the limitations that we have proposed, the table in the agenda items only includes people who do not have multiple disciplines. Also, significantly, the Farkas study did not include a multiracial ethnicity, which the State Bar includes as part of its attorney census. So the Mission Advancement Division went back and compared the license numbers for those attorneys that were included in the Farkas study with the ethnicity reported in the 2024 attorney census. Compared to the active attorney population, attorneys who previously identified as Black in the Farkas study account for 6% of the licensees who identify as multiracial in the 2024 attorney census. The same is true to a greater extent of Hispanic attorneys. This suggests that if multiracial was not one of the categories in the table shown in the agenda item, an even larger percentage of Black and Hispanic attorneys would benefit from the proposed policy options, and in fact will if adopted. Similarly, this suggests that if multiracial ethnicity were available for Farkas participants, the 10.2 number that you see in the table would have been much lower, or at least lower. So the proposals for removal of discipline history from the attorney profile page are removal of non-disbarment discipline 10 years from the effective date of the discipline. And this would grant relief to 1,642 licensees, at least as of May 2nd, 2024. An alternative would be to slightly expand the availability of relief for public reprovals and reduce that time frame to 8 years, leaving at 10 years relief for all other non-disbarment discipline. That would add an additional 48 licensees who would be granted relief. And reducing the public reproval time frame to 8 years is not really warranted by the recidivism data, as you can see in the table in the agenda item, nor will it grant the relief to a significant number of people, but we wanted to include it in case the board wanted to consider it. Regardless of which option the board elects, the recommendation is that the relief would only apply to licensees in the listed statuses. It would not apply to licensees who are not eligible to practice, for example, involuntarily inactive, and would not apply to licensees with more than one discipline, as I mentioned earlier. As for stakeholder feedback, we didn't go back to talk to the stakeholders again after the last board meeting, but I wanted to note that generally the prior options that we put forward to the board, several stakeholders thought those timeframes were too long. And for example, Cable recommended using timelines that are in rules 9.8 and 9.31 of the rules of court, which is 7 years, as a guide for the removal of discipline information from the profile page. And ADDC suggested 5 years for public reproval, 8 years for probations with stayed suspension, and 10 years for actual suspensions. I also want to note that Trustees Good and Buenaventura, who obviously are here today, but were also on the commission, on the ad hoc commission, during the September 2023 meeting, expressed a strong preference for the commission's timeframe as opposed to the recommendations of staff. In regard to the current proposal, but not in time to make it into the agenda item, we did get some additional feedback from OCTC. And OCTC expressed some concern about the website removal and to a lesser extent, the expungement being triggered from the effective date of the first discipline. For example, suspensions with standard 1.2C conditions that extend the suspension until the lawyers provides proof of rehabilitation, fitness to practice, and present learning and ability in the law can extend a suspension for significant periods of time, which may bring that suspension close to or beyond a 10-year period from the effective date of the discipline. In these cases, the discipline would be removed from the web page as soon as the suspension ends or shortly thereafter. And in that case, OCTC was concerned that the public would have very little notice, if any, that the now active attorney had just very recently served a very lengthy suspension. So OCTC's suggestion was for actual suspensions to make the period be 10 years from the effective date of this discipline or 5 years from the termination of the suspension, whichever comes later. And Mia is going to address expungement in a minute, and that potentially addresses the same issues, although it's maybe less significant given that the time frame there is longer. So I'll turn it over to Mia.
Thank you, Steve.
Expungement.
Thank you. Good morning. again, as Steve mentioned, I'm going to talk about expungement. Our proposal is that expungement is designed to provide greater relief than removing discipline from the attorney profile page, and to distinguish that from removal from the discipline from the attorney profile page, we are proposing to define expungement broadly. And under our proposal, the time frame to seek expungement should be greater than the time discipline is removed from the website. So the proposal is that non-disbarment discipline be automatically expunged 20 years from the effective date of the discipline. Now, this is a departure from the current practice now, as licensees must petition the Supreme Court for expungement. The proposal would grant expungement relief to 1,895 licensees immediately, and that is, as outlined in the item, 554 active licensees. Now, the impact of the proposal is that the discipline would be removed from the public discipline history. Expunged discipline will be removed from the State Bar Court docket search portal. The thought is that there would be a notation on the website that would show that the discipline has been expunged, and the discipline would not appear in a certificate of standing. The State Bar would not provide information about the discipline to members of the public or in response to a California Public Records Act request. Expunged discipline could not be used either as an aggravating circumstance or as a prior discipline. This also distinguishes it, again, from expungement from removal of discipline from the attorney profile page. I will note that the State Bar's internal records would be sealed, but there would be 3 exceptions related to that. First, the proposed definition of expungement does not relieve the licensee of their duty to disclose the discipline for purposes of eligibility for a judgeship. And then the State Bar also would continue to compile and maintain those statistics for on-attorney discipline. And finally, OCTC, our proposal is that OCTC can consider expunged discipline for internal investigative purposes and for consideration of eligibility for the new diversion program. I will, Steve, if you can advance the slide, just want to highlight some of the limitations on expungement. To have non-disbarment discipline expunged after 20 years, the licensee must have status active, inactive, and resignations without charges pending. I will note that it would also apply to deceased and presumed deceased attorneys. They, again, only have one discipline, not previously have discipline expunged, and not have disciplinary matters pending in State Bar Court at the time the discipline would otherwise become eligible for expungement. Again, as Steve also highlighted, given the statistics as outlined in the item, we believe that Black attorneys are getting a relief to a greater extent the population or the attorneys who were disciplined in 2022 based on the diversity report as well as the attorney discipline report, which highlights discipline for attorneys in year 2022 as well. I do want to highlight the feedback that we received from stakeholders on this item. OCTC previously expressed support for expungement by petition, but did not object to proposal of automatic expungement at 20 years. They believe that the Supreme Court should retain discretion to grant or deny petitions for expungement. They also raised 2 other points that I'd like to just share. One, when discipline is imposed, the Supreme Court generally creates its own docket that will include the Supreme Court's discipline order. The question is what happens with the Supreme Court docket following expungement. We don't know how the Supreme Court wants to handle this, but we do anticipate that expungement would only apply to State Bar Court records. And under this proposal, the existence of the Supreme Court record would not alter the proposal that there would be a prohibition on using them as priors. The other question that OCTC raises concerns what happens to published and unpublished opinions from the review department and or the Supreme Court. We would propose that even after expungement, those opinions would remain in place and would not need to be redacted to include the respondent's name, and that the published opinions could continue to be cited as precedent. Lastly, the State Bar Court wants to share that they want to maintain a record of all licensees' discipline, not limited to a time period. They also express no position on whether the website or public profile should or should not contain more information, should contain information related to discipline. They would also defer to the Supreme Court, and if they want to limit the time that prior discipline may be used related to an aggravating factor.
Great. So we'll open it up if there are any questions. Happy to address them.
All right, thank you for the presentation. Trustee Buenaventura.
Thank you, Mr. Chair. To me, what I'm seeing in front of us, what's being presented is not moving the needle in any significant way. To say that you have to wait 10 years, 20 years to get your record expunged or the name deleted off the website really has no significant impact. And again, I want to bring it back to, if a lawyer is disciplined, I understand, we have to understand, once the lawyer is disciplined, action has been taken and they are paying the price for whatever misconduct they may have committed. So no one's getting away with anything, right? They have done some wrong, whatever penalty they must face, they've paid it. So then the next process is, how much time should they wait for them to get their life back on track, for them to get their career back on track? And to me, waiting 10 years to 20 years is, it's too late. Most lawyers practice in the same jurisdiction for a long time. Most lawyers don't move around from city to city, county to county. Most lawyers and reputations are intact within that community. And so they will already have faced that scarlet letter on them for this interim period while their record is exposed, and rightly so, because they committed some wrongdoing. But for them to have to wait 10 or 20 years is fatal to their career. And I think, having made a mistake and having paid the penalty for it, there should be some relief. This is why the ad hoc commission was created. This is why hundreds of, maybe perhaps thousands of hours were devoted to studying this issue. And I think we should seriously consider reducing the amount down from this 10 and 20 years to something that is more reality-based, something that's more compassionate, something that's more understanding of what a lawyer will face. Imagine a young lawyer, for example, who makes a mistake, right, and gets disciplined. You know, their career is pretty much over. He's got to wait 20 years, because that's what a lawyer's career is. And I just don't see the fairness in that. And I think we can do better. And I appreciate the staff's recommendation and all the hours they have put into looking at this issue. And again, I brought up the thing about the diversionary system and the support the legislature has for it. And I think even the country's support of second chances and of people getting an opportunity to redeem themselves And I think that's what we're about as a country. And I think that a 10 and 20-year gap in time is just not going to do it. It's not meaningful reform. And so I hope my colleagues would dig a little deeper and try and understand what a young lawyer, for example, does and how this will affect his or her career in the future. And I just think we can do better. So thank you, Mr. Chair.
Trustee Huser.
Yeah, I'm very moved by those comments and, think they're extremely important. I just wondered if the commission outlined why they came up with the 7-year versus 10-year, and if that could be shared with us here, because obviously they thought for a long time about what those factors should be and what that timeline should be. And can we share that here?
I don't, maybe Trustee Good or Trustee Buenaventura can remind me, but I don't remember the commission coming up with a 10 or 7-year guideline. Their guidelines were significantly lower than that. The 7-year, I believe, comes from Cable's response to the stakeholder interview, where they said that 7 years, which is in the rules of court for administrative inactive enrollment expungement, that could serve as a guideline for the disciplinary history. And the 10 years is really from the discipline data and from other regulatory agencies. As you can see, one of the pending bills in the California legislature right now is about real estate appraisers, and that is lowering the display of discipline history from indefinite to able to be petitioned to be removed after 10 years.
And Steve, can you just remind the board what the ad hoc recommendation was, those timelines?
Yes. So for private approval, it was set at 1 year or when the conditions are met. And public approval was 3 years. Probation with stayed suspension was 3 years after the conclusion of the probation. And actual suspension was 5 years from reinstatement. And disbarment remained posted indefinitely, which was no change.
All right. I'm going to go to Trustee Tony, then Trustee Good.
A couple of things. One is overall, I really appreciate the fact that this is an issue that we have discussed over several meetings, because this is one that's more important to get right than to get done fast. And I think, I've seen this in, various iterations. On one hand, I do like what I see in front of us. I'm also sensitive to Trustee Buenaventura's, point about, well, if an attorney makes a mistake, and how long should they pay for it? And I do think, there were earlier proposals where there were, recommendations for gradations based on the severity of the discipline. I do think that there are some offenses. George Cardona, the Chief Trial Counsel earlier, gave us some examples of some of the some of the cases that were being tried by the State Bar Court. And as I looked at them, there were some that I thought were more egregious than others. Some, yes, maybe were mistakes. Some that seemed to be, serious crimes. Okay, and if you're, found guilty, you're guilty of a crime. It feels like more than a mistake. So I guess my point is, I would have some openness to saying, Well, maybe some are 10 or 20, but maybe not all of them. That's my only point.
That's a great point, Trustee Tony. And we did look at that. And as you can see in the recidivism tables, we had it divided up by what the first discipline was. And what we found was that the percent of those licensees who were disciplined and subsequently recidivated was not significantly different, regardless of the type of the initial of the nature of the initial discipline. And as a result, we didn't really differentiate in our proposal between those. But your point is well taken.
Well, there is an option that has the public approval at 8 years versus other discipline at 10. So that is the differentiation, that option.
All right, great question. Trustee Good.
Thank you, Chair. So I wanted just to start off by saying I spent a lot of time on the ad hoc commission, and I was in fact on the subcommittee that talked about the expungement issue, as was Mr. Moawad, as was Mr. Buenaventura, all of us representing sort of different perspectives here. We spent a lot of time on this issue and developed, to Trustee Huser's point, the original proposal, which is on page 2 of the memo that we got, where we tried to come up with a framework that looked at the severity of the discipline and then tried to match that against the time period. So, and again, disbarment, there's no expungement for disbarment. So it ranged from private reproval to probation with actual suspension. And the timelines then ranged from 1 to 5 years, depending upon the severity. And I think the overarching concern of the ad hoc commission, which was formed to redress racial disparities in the California discipline system that were really quite egregious, was to figure out, is there a path forward for some of these lawyers who have been disproportionately affected, in particular Black male attorneys in California? What path forward are we going to give those folks? And I think expungement was a big part of that, right? Giving somebody the opportunity to get their license back and be an attorney, if they otherwise have not been disciplined since, and all of the other sort of contingencies. And so when I got this proposal, particularly the 20-year proposal, I mean, I was distressed. This is just not real. You know, this is expungement in name only, but not in reality, to echo some of the points that Trustee Buenaventura made. And all you have to do is look at who would be affected, and basically half of the people who would have expungements now are dead or presumed dead. So it's just not real. So, and then as I dug into some of the data that was collected, the data on its face suggests to me a lesser rule than 20 years. And, you know, in particular, if we look at, and I found it very interesting because we hadn't seen this before, data on sort of repeat offenders and when they might offend. And if you look at that data, which is at the bottom of page 4 of the memo, which very nicely sort of divided up the discipline by the kinds of discipline, which I appreciated, we find that really at the 5-year mark, you know, 75% of folks who had a first discipline are gonna reoffend, right? That's most of it. And by the time you get to 9 to 10 years, it's 94%. And then the data itself doesn't track it from 10 years to 20 years, you know? So for the remaining 6%, that trickles in from year 10 to year 20, and then suddenly we're presented with year 20 is the right call here. Well, this data itself doesn't even support that to be the right call. It wasn't broken down over that time. And what is the right answer? Is the right answer when you get 100%, or is it something less than that? And I submit it should be something less than that. So, you know, I don't think this data doesn't support the 20 years. It's just plucked out of thin air. You know, maybe at that point, yeah, everybody has died and they're not going to reoffend. But the data to me suggests something less. And maybe it's not, you know, maybe it's not the original time period that the ad hoc commission suggested, although I like them. Maybe it's a little bit higher. But it's nowhere over 10 years and certainly not 20 years. And so the way that this is kind of written, I cannot in good conscience support this. I will not support this. We have to have a different proposal in front of us because it doesn't redress any of these inequities. It doesn't do anything, and it's not real expungement. So thank you.
I do think it's important to note that the reason that a significant portion of the people who are getting relief under the expungement proposal are dead or presumed deceased is because we're going back to the beginning of time, right, for the state bar, which is 1927. So because those are eligible statuses for the relief, there obviously are a number of people there who would be entitled to that relief going forward. You know, presumably those people would, the vast majority would be alive. The other thing to note about the data points brought up by Trustee Good are that the study really, it was a 10-year study. And so that some of those people, many of the cohorts, if you will, only had 10 years, right? Or 11 years or whatever to look at the recidivism. And so, you know, we don't know what percentage would be reoffending in that greater time frame, number one. And number two, the percentages that were cited in there are only of those people who did reoffend within that time frame.
I'm wondering if Trustee Good or Buenaventura, you want to recommend specific alternate timeframes for the board to consider. And before doing that, I just want to reiterate the obvious, which is this is a really complex set of issues, and we're trying to weigh multiple factors, including even with the staff proposal, which I think some don't welcome. That would make our organization an outlier when compared to other attorney licensing agencies or other licensing agencies in terms of its progressive nature. You know, but for, I believe, 2 states which don't post any discipline on the website at all, you know, we would be very progressive in implementing even the staff recommendation. So I want to put that out there, and there is some risk, I think, associated with that. Also want to clarify for the board, whatever you decide on website removal is something we can effectuate on our own motion, so to speak. With respect to expungement, we will need to draft implementation rules for the Supreme Court to approve. In developing this recommendation, we did consult with our Supreme Court liaison, specifically on the expungement recommendation. And I do believe that if the board adopts a significantly more aggressive posture, there is a likelihood that the Supreme Court may not approve it. That, you know, is neither here nor there. Really, it's not dispositive for you, but I did want to provide that context and information, and then just maybe ask for some alternate proposals for the board to consider.
Before we get to alternative proposals, I do want to hear from Trustee Shelby.
Actually, first of all, thank you, Mr. Chair. That was in alignment with where I was going. My questions were, and I want to thank Mr. Moawad and Ms. Ellis for the presentation. But I heard clearly from Trustees Buenaventura and Trustees Good, and because of the significant amount of time that they spent on this issue, very interested in terms of their position and posture. So my first question was around timing. My second was around any recommendations that they may have as it relates to moving forward. So that's where I am.
Trustee Buenaventura.
Yes, thank you, Mr. Chair. So just in bringing it back to timing, and I come from the criminal defense background and as a public defender. In criminal cases, the timing is that a normal felony, you're placed on usually 3 years probation. So at the end of that 3rd year, you can then apply after you finish your probation to get your case expunged. Sometimes your case can go as long as 5 years probation, but it's only at the end of that can you get your case expunged. So I guess what I'm saying is, if the criminal world has a provision that basically says that you can do it in 3, perhaps that's a good starting point, 3 years. And again, I want to be being mindful of, these are not, these really egregious cases where someone got disbarred. All right, obviously, as Trustee Good had mentioned, we're not talking about those kinds of cases. Those are done. They're never going to be expunged. Disbarments are non-issue. They will always be known by the general public. But as far as the timing, I think a 3 to 5 year period is a legitimate and a reasonable period of time to ask for an expungement, because that gives plenty of time for the person to be rehabilitated, if you will. It'll be plenty of time for them to correct their behavior if need be. And it will be again, mindful of additional time. They will be under this sort of cloud that they've been disciplined and that they'll have to live with. But it should end sometime and not for 10 or 20 years. Thank you.
Great, yes, Steve.
Oh, I'm sorry. Trustee Good had her hand up before I did.
Okay. All right, Trustee Good.
I was just going to say, I appreciate Trustee Buenaventura's thoughts on this, and I completely appreciate the criminal justice system's a backdrop on expungement and wanting to give people second chances, all of which make good sense to me here. However, I'm willing to compromise on this, and I was going to suggest 8 years. If we look back at the commission's original proposal, I still think it should be staggered by the kind of offense, but I would move the 5 years from reinstatement to 8 years. And I think that's also justified by the data that we got about repeat offenses on page 4, where at the end of 8 years, 90% of people who are going to repeat will have repeated. And then they'll be taken out of it. So in the interests of compromise and trying to reach consensus on the issue, I'd be willing to make a proposal on the expungement front of 8 years. And then kind of work, I actually think websites should dovetail with whatever we're doing on expungement, which was the ad hoc commission's philosophy. If we want to disconnect it, then it should be less over there. But expungement for me is the really serious issue that will drive the other decisions. So I'd be willing to make a proposal in that regard if it had consensus here. And I would hope that if the Supreme Court looked at everything that we've looked at, which it probably hasn't had the time to look at, that it might find that this is reasonable and appropriate as well.
Okay, Steve, did you want to respond to any of that?
Well, yes, add a quick nuance, and that's just that I also come from a criminal background, curiously on the opposite side from Trustee Buenaventura, but the definition of expungement in the criminal world is significantly different than the definition that we have proposed here, which is extensive relief, including that it could no longer be used as a prior and could not be an aggravating factor in future discipline, which is very different than the relief that is sometimes been referred to as expungement here in a criminal arena, which is 1203.4 relief, which really only says that they don't have, the person who was granted the relief doesn't have to tell potential private employers about the conviction. They do have to tell government employers in most circumstances, and it's still a prior and would prohibit them from owning a firearm and all of those other things that come with being a felon or other, not otherwise getting that relief. So I just wanted to point that out. As for the time frame, the concern that we had discussed previously was that if somebody was likely to reoffend, but we had removed something from the website, that it put us in a position of creating doubt in the public. And that was if we had something prior that was removed from the website that was then used as a prior in a subsequent disciplinary proceeding, but wasn't on the website when the client went to go hire that attorney, that they may feel like the State Bar was protecting attorneys unnecessarily. Of course, Trustee Good's point about aligning the website removal and expungement would eliminate that concern. But if we're making that too early, that may also raise some public protection issues. And of course, the board has the discretion to do whatever the board wishes. But I just wanted to raise those issues.
I was seeing other hands. I'll wade into this. And I think, Steve really kind of hit the nail on the head with something that has, I guess, troubled me during our discussions of, how do we as a licensing agency continue to protect the public, especially in light of the public's perception of the State Bar in the wake of the Girardi issue and other issues. And when I look at, I have a very different take on the data than Trustee Good. I think the data absolutely supports the 10-year mark for removal from the website, and the 20-year mark. While that does seem like a significant amount of time and a significant amount of time relating to an attorney's career, I don't think that we can look at that. Look at that recidivism data, and basically disregard it. I think we owe it to the public to look at the data that we've compiled. I think anything less than 5 years is definitely not supported by that recidivism data. I would also add that one of the things that former trustee Mark Broughton and I have been working on for several years with Melanie Lawrence is a redesign of the State Bar probation program, and aligning it more in line with current trends of probation departments, and making sure that the type of rehabilitation that we're offering to attorneys, the type of counseling or probation restrictions are in line with what they've either been convicted of or the actual harm to the public. So we're going to be rolling these out. I think we're going to be in a position to be able to bring more data to the board in subsequent years as we see how effective that probation redesign is. And from a policy maker standpoint, what I would prefer is to have a longer time period in which there's more time relating to removal of the information from the website, more time allowed regarding actual expungement. And during that time period, I think we can bring it back. We can continue to study this. We can continue to have more information presented to us regarding recidivism. But I think the numbers absolutely support staff's recommendation. And if we were to go underneath it, either that 5-year mark or the 8-year mark, I think that would significantly damage our position in regaining the trust of the public. I am also mindful that we continue to work with stakeholders in the legislature to see what their thoughts are. Certainly the legislature drives the criminal justice reform that's taken place in California. But I have had previous interactions with other legislators who have cautioned on having a direct or having the same sort of timelines that the criminal justice system has, and that we owe it to the public to warn them of bad actors and to make sure that the public's fully informed. So those are my thoughts. I am in support of staff's recommendation, and we'll eventually get to a roll call vote here. Before that, though, I see Trustee Huser has her hand up.
So, I really appreciate all the comments, across the board on this, but, from what I've heard, nobody has challenged that the recidivism data shows that 5 years, something like 5 years is, the vast majority, the overwhelming majority of when people are likely to reoffend, and therefore something in the compromise area of 5+ years seems reasonable to me. The other issue that was raised by staff of what, we call expungement, that you can't even consider it a prior offense or something, we can always redefine what we call expungement so that it can be considered a prior offense in a future offense, but that doesn't mean you have it on your website, you have it as, something that can be considered for other purposes. So you can limit the definition of expungement if that is seen as a direct issue. And then I just want to call back our attention to what I heard from the staff presentation, what I've heard from other trustees. The disparate impact here is unquestioned as far as I understand it. And that is something when we are held to protect, the public, protect attorneys, protect people, we are also obligated to protect against things like such an egregious disparate impact as we see in this particular area. And to the comment that we would be an outlier in all of this, being a leader is not always a bad thing. So that's my views. I would go for a compromise, similar to what Trustee Good suggested.
Trustee Buenaventura.
I am ready to second the motion by Ms. Good if she were willing to make it, because I do believe a compromise is something that we can try to come up with. I am understanding of your Mr. Chair, your concerns about protection of the public and not necessarily following the criminal law guidelines on what happens in criminal cases and things like that. And so from what I'm hearing, I think a good compromise suggested by Ms. Good is the next best alternative in my mind. And I'd really like to move this forward, and I'm hoping that we can do so. Thank you.
So Louisa, I sent you a document. Maybe you can try screen sharing it. I just took the resolutions from the item and then I added some new alternates. So maybe that would be the easiest.
Oh, okay.
Okay, well, while we're pulling that up, can I have Trustee Barahona?
Yeah, thank you so much, Chair. Leah, can you remind us again about the role of the Supreme Court as it relates to the compromise that's being presented?
Right. Well, regardless of which direction the board goes in today with respect to the expungement recommendation, we will need to draft implementing rules that would need to be submitted to the Supreme Court for approval. So the board is not the final sort of say or word on the expungement piece.
Thank you.
I did email. So if you haven't received it, Louisa, maybe I will screen share it and do the annotations. We'll see how this goes.
Okay, Sorry, I don't have it
Good.
yet.
I'm definitely not the expert. I don't know if people can see this. I basically have, I just took what's already in the item. So you're gonna see, I'll make it bigger now. You're gonna see things that I know you don't want to approve. So basically, let's just start with expungement, going with Trustee Good's suggestion that this drive the conversation. The staff recommendation is here 20 years. I just drafted as an alternate 5 or 8 years. Thinking that if you wanted to have a lesser time for website removal, you go maybe 8 years on expungement, 5 years for website removal, or 8 years for both, or 5 years for both. So maybe
Trustee Good and Bonaventura, does that track with your motion?
Yeah, I was just gonna say on the website removal point, in order to sort of effectuate one of our goals here, which is complete transparency with the public, it only makes sense that there's website removal when there's true expungement. And that's kind of why, in my mind, the two issues are linked together, as opposed to separate. But maybe we don't have to go there. I'm okay with the suggestion of 5 to 8 years with that in mind. But we also can just mark up the original proposal on page 2 of the memo, which really seeks to quantify things by the kind of discipline that was imposed, if it was greater or lesser, and can track back from that. So that's more a question, because there, we have it from 1 to 5 years, and I think it should probably be something like 3 to 8 years instead, just kind of tracking those numbers. And I would just make website removal the same. For transparency reasons. Why should it be different in my mind? I've never understood the argument for why it should be different. It should reflect reality.
Okay, I would just say for ease of actually getting this implemented, it would be helpful not to have so many different gradations based on discipline type. Certainly, we could do it and we could get there. It's gonna be more difficult. So it would be easier to have 1 or 2 rather than multiple. But that's what I would just say from a technical perspective.
Okay, then I'm fine with your proposal 5 to 8 years there.
Well, this is 5 or 8. I was thinking the board would. Yeah.
5 or 8, right?
Yeah, whichever one somebody wanted to make a motion regarding, it's ready for me to edit.
Okay, so Sarah, did you want to make a motion? And is
Sure,
your
I'll
motion
make a motion.
on
I
what's?
would make it 8 years. I would make it 8 years as I proposed, as a
And-
compromise.
right,
And
and
it's higher than it would be in the criminal justice system. I do think that's warranted because of the special position that lawyers have, and because of our public protection obligation. So I would make it 8 years.
I'll second the motion.
Okay.
Does George have a question? I see he has his hand up, and maybe we should hear his comment.
sure, Louis says that's something you need to effectuate. I don't know.
No, George.
I'm here. I can, if, so, 2 questions, Trustee Good. Again, this comes back to with the actual suspensions, is that going to be 8 years from the effective date or 8 years from the reinstatement? The original proposal in the ad hoc commission was 5 years from reinstatement, which I think addresses some concerns. Second question is with respect to expungement, given that if we're going to significantly shorten the time period for expungement to 8 years, what's the position on altering the definition of suspension of expungement so that if someone does commit another disciplinable act, the prior quote expunged discipline could still be used as a prior. In other words, they would still get the benefits of not having it publicly disclosed, but if they do come in with another disciplinable offense, it could be looked at as a prior, which is akin to kind of the criminal approach.
Speaking for myself, I would have no problem with carving that back. In other words, that it could be considered as a prior if somebody was to reoffend. So, you know, in my mind, and other trustees might disagree, I have no problem with changing the definition there and permitting it to be used as a prior for some period of time. And then I'm sorry, your other question, I was losing track there, George.
The other question was the ad hoc commission's original thing for
Yeah.
had the time periods running from different points. In other words, for probation, it was running from the conclusion of probation, which makes some sense. And for actual suspensions, it was running from reinstatement, which also makes some sense.
Yeah, I would do reinstatement. I guess that makes it longer, right?
Potentially, yes.
Yeah.
So for example, if someone got probation with a 2-year actual suspension as a condition, the probation would run once they had finished serving their suspension.
Yeah. I would keep the ad hoc committee's recommendation and have it be reinstatement.
Leah, are you able to add that language to alternative 1?
I don't know that it needs to be added as alternative 1 because we don't have the definition here in the alternative, and we have to bring back the rules to the board for further action. So I think we could capture it in the implementing rule.
Well, it's up above in your previous, if you scroll up, it's actually in there. I thought.
This is no longer.
Okay, so you took that out.
Yeah, it would just be this. And in fact, I don't know that we need a website removal resolution if expungement is what we're voting on, because as part of expungement, one of the effects of expungement would be website removal. So I'm not sure, Steve, unless you disagree. I don't think we need a separate website removal.
No, that's correct. Currently the definition does not include removal from the attorney profile page, but that's only because there was a separate earlier timeline that accomplished that same goal. We could certainly include expungement we could define expungement to include that and just have one resolution if that's the way the board wants to go. The resolution does say from the effective date of the initial discipline, however, and that I think is the part that George was talking about.
Oh, okay.
So you could just change that to give options in the rule drafting from the effective date / completion of the initial discipline, which would give flexibility in drafting the rule and coming back with a proposal for the board to consider.
Okay, so we have alternative 1 up. That was moved by Trustee Good, seconded by Trustee Buenaventura. Good or Buenaventura, any other changes to what is presented on the screen?
None for me.
Did we just scroll all the way down again? I guess
This is the, the second further resolved here is about implementation of your recommendation, statutory amendments. And then the next is about the conviction transmittals was another aspect of the recommendation.
And then the final one does talk about website removal.
The final one is about website removal, attorney discipline, from licensees who resigned without charges pending.
Oh, okay. All right. Yeah.
Okay, so should we take it just
You've
on
got
alternative 1, or can we take all the other further resolves?
Well, you have Trustee Tony with his hand raised.
Okay, sorry, I can't see. Yeah, I can't see
somebody
it.
else that I can't see either. So do you want to take Trustee Tony?
Yes.
This is more of a clarification question. Does this proposal say 8 years for expungement? Does that assume that there's no more offenses that have been found in that 8 years? Or is it 8 years for each offense on a rolling basis?
If you're asking me, our original proposal was that it was for assuming there were no additional offenses. And so that relief would not be available for somebody who had multiple disciplines that did not occur at the same time. But obviously this is the board's resolution, so it can be whatever the board wants.
Okay. What I would like an assurance is that the understanding and that this is written in such a way that you can get it expunged if you don't have another offense that you were found guilty of, or whatever. I don't know if that's how it's written, but that's what I would like.
That is reflected in the item. And I think when we come back with the implementing rules, you'll see that.
Trustee Tony, does that satisfy your concern?
Absolutely. Thank you.
Okay. All right, and I'm sorry, I can't see anybody else who has their hand
No,
raised.
there isn't. It's not, no members of the board.
Okay. So in regards to the resolution, is there any other discussion regarding that 8-year period? And again, I can't, because I'm on the device that I'm on, I can't see whoever's raising their hand. So just go ahead and speak if you want. All right, hearing no further discussion, Louisa, can we have, and just point of clarification, we're just voting on alternative 1, and then we'll take up the further resolved kind of wholesale, or are we comfortable doing all the further resolved along with alternative 1?
Trustee Good, since you made the motion, are you comfortable moving all of these resolved?
Yes, I am.
I don't know that we got a second.
Second.
Yeah, we got a second from Ray.
Okay.
Okay. All right, so is everybody clear on what we're voting on? Any questions? All right, hearing no questions. Louisa, can we take the roll call, please?
Barahona.
Aye.
Buenaventura.
Aye.
Chen, not present. Cisneros.
Aye.
Good.
Aye.
Huser.
Aye.
Shelby.
Aye.
Stevens.
Aye.
Soel.
Aye.
Tony.
Aye.
Trejo.
Aye.
Stallings.
No.
That's 9, no, I'm sorry. That's 10 ayes, 1 no, and the motion carries.
All right. Well, I want to extend a thanks to all who participated on the ad hoc commission on this one system. Like Trustee Buenaventura said, hundreds, if not thousands of hours spent on all the issues that were contemplated by the ad hoc commission. And this is certainly one of the most hotly contested and debated items. So thank you to the board for wrestling with this, to staff for your expertise and for guidance in this, and just all the stakeholders who have participated. So thank you. And this concludes the Regulation and Discipline Committee meeting. Just as some housekeeping, we're going to be going into closed session momentarily here, but I would like to take, after we go into closed session, what I plan on doing is having a break for trustees to go grab some lunch, and probably coming back at 1 o'clock, 1 o'clock into closed. Does that work with everybody in your situations right now?
Do you mean just taking a break now and then starting closed at 1, or you mean going into closed and then taking a break?
We'll go into closed now, and then the first order of business would be to break for lunch. And then that way, when we return, we can return back into closed and complete our business. I would, if we have that timeline, I would anticipate coming out of closed at approximately 3 p.m. this afternoon. All right, seeing no strong objection. Let's pull this up. All right, we're going to be going into closed session pursuant to Government Code Section 11126 sub E sub 2 sub C. Government Code Section 11126 sub C sub 1 and Business and Professions Code 6026.7 C3. Government Code Section 11126 sub E sub 2 sub B sub I. And then Government Code Section 11126 sub E sub 2 sub A. All right, I think that covers it all. So members of the public, we should be back in open session at approximately 3 p.m. this afternoon. Board members, go ahead and grab lunch and then be back at 1 o'clock, and we'll convene into a closed session at that point. You should get a unique Zoom link for that closed session. All right, anything else I need to cover before we take our break? All right, see everybody back at 1 o'clock.
We'll be
We don't need to take a roll call.
No.
All right, this is Brandon Stallings, Chair of the Board of Trustees. We are out of closed session and there are no items to report on. We're going to continue on with our business calendar and going to item 701, which was tabled, moving on to 702. This is discussion and approval of current and new 2024 legislative priorities and affirmative legislative proposals. It's being presented by Chief Mission Officer Donna Hershkowitz and Bridget Gramme. So welcome.
Thank you, Mr. Chair, members. Okay, there's Bridget as well. Donna Hershkowitz. Just wanted to present this legislative priorities item to you today. Starting with a quick update, several board members attended the Judiciary Committee hearing held on April 30th. Other board members I know listened with rapt attention as the committee considered the State Bar's request for a much needed fee increase. I'm going to project on the screen, I'm going to share my screen and just project the table that you saw in the agenda item, just so we can very quickly go over what is contained in the fee bill now as it is in print versus what the request was that the State Bar had put forward and that you all took a position on. So this is the table, as I said, that was in your in the agenda item. It identifies the amount of it identifies the fee increase that the State Bar had identified was necessary to maintain public protection. We also referred to this as the fee that was necessary to maintain existing operations and services, or more colloquially to keep the lights on. That, as you can see, the State Bar requested $95 as the amount that was necessary to fund the costs of the building lease, contractual obligations to our staff, as well as IT licenses and subscriptions, and to keep us at an 8% vacancy rate, which is where we were at when we presented, when we came up with the original proposal. So that was a request for $95 that was presented to the legislature as absolutely necessary to maintain our existing operations and service levels. We were very pleased, obviously, to see that the legislature did recognize a significant portion of the need that we identified. funding 54 of the $94 to maintain our existing operations and services, and funding 11 of the $30 that we had identified as necessary to take some real steps to improve our public protection efforts. You can see by this chart, really focusing on the top part of the chart where we identified what was necessary to maintain existing service levels. Well, let me back up for just 1 second. Where did this number come from? This number of needing $95 comes from the fact that we have an ongoing $20 million structural deficit. That is what this $95 fee increase was intended to address, was that $20 million structural deficit. So the legislature, you'll see, did not fund the entirety of the amount that's needed to meet the cost of the building lease for our San Francisco building. And they were seeking to protect our rank and file staff. They were seeking to provide sufficient funding to meet the contractual obligations contained in our memorandum of understanding with our bargaining units for cost of living adjustments, benefits, and merit increases. They were also seeking to transition us, sort of phase us into a 15% vacancy rate by April 2026. And so in lieu of our request for $35 and $39 that would cover these amounts as well as our IT licensing costs, they provided $39 with the intention, again, of funding those specific things: COLAs, merit increases, benefits, and getting us over a 15-month period to a 15% vacancy rate. The legislature specifically, and I'm going to stop sharing this, the legislature specifically invited us in conversations as well as in the written analysis, invited us to update that number that they had identified, that $39 for our staffing obligations. They indicated that they didn't have sufficient clarity on what the precise amount would be in order to fund those particular items. They expected that it was more than $39, and they invited us to provide them additional information and committed to ensuring that they were helping us meet our obligations to our rank and file staff. This past Monday, we submitted a proposal to the legislature. We submitted the data that they had requested that would identify what was needed over and above that $39 to fully fund what they had set forth as their goal, which again was the cost of COLAs for our rank and file staff, merit increases, meeting the increased cost of benefits, as well as transitioning to the 15% vacancy rate. Instead of $39, the amount that's needed to fund that is $52, and that was what was included in our submission. At the same time, we also submitted to the legislature a proposal for funding that was needed to support a modern and safe information technology office. You'll recall that when we presented to you the justification for a fee increase report that was ultimately submitted to the legislature on April 1, that report included a TBD for the information technology item. The reason was we had brought in some consultants to give us their estimates to do an evaluation of our IT systems and our IT staff and what was needed to improve that. We were continuing to refine that. The original number that we had received was significantly higher than we thought appropriate and higher than several other consultants that we brought in thought appropriate. And so we wanted to make sure to get that to a number that we felt and other consultants felt was justified. And so ultimately, what we submitted, and you see this in your agenda item, we submitted a requirement for some one-time costs, $700,000 or so for IT modernization initiatives, $400,000 for a client security fund system to take them from a paper-based system and allow them to be more efficient. And $4 million toward a attorney regulation information system, something that we've for years been calling ARIS. We've been wanting to deploy. It's not something that we have been able to implement, to develop or implement over these many years, and so that also requires $4 million. So we're looking at one-time costs of $5 million, recognizing that likely this board, as well as the legislature, was not going to have an appetite for further increasing the fee request that we had put forward. What we proposed was funding this $5 million out of the excess reserves in the client security fund. This is consistent with conversations that this board has had in the past about using all of our pockets of reserves in order to make these key investments that will ultimately allow us to have a more modern system that will allow us to implement efficiencies that we frankly cannot do today. We are looking forward to having conversations with legislative staff, first in the Assembly and then in the Senate, to talk through the additional proposals that we had submitted. We also took the opportunity while we were submitting the additional IT, the need for the IT improvements, to further explain the IT license subscriptions, IT licenses and subscriptions. That was originally part of our the amount that we needed to maintain public protection. There was $9 that was identified for that. The legislature really had a hard time parsing through our request and understanding what part was for IT. And so they didn't really consider it. They really focused on the obligations to staff, but said that when we submitted these additional IT modernization proposal, that they would obviously, be happy to take a look at and consider whether or not there should be funding for these IT licenses and subscriptions that have realized significant cost increases over the past couple of years, and that's why we were requesting funding for that. So we provided that detail as well. What the board needs to consider, and we're going to go on in a second to sort of two affirmative legislative proposals, but what the board needs to consider at this time, based on the fact that the board had approved supporting AB 3279 as amended, if it was amended to include a $125 increase to the licensing fee, divided as you saw on the table that I had projected. Does the board want to continue that as the advocacy position, really identifying that as the continuing need of the bar, or at this point, in light of what the legislature has put into the bill, the $65 as opposed to the $95, does the board want to reconsider its position at this time? So I'd like to have the opportunity for Bridget to talk briefly about a couple of other affirmative proposals and then open it up for discussion.
Sure, thanks, Donna. So as you can see in the item, we do have a couple other items that we are recommending for affirmative proposals. One of them has to do with just giving us the flexibility, the continued flexibility to use CSF reserves to spend on IT and staffing. Right now, the CSF reserve fund is at we project it to be about just over $9 million at the end of this year. And so per the proposal that Donna mentioned, would like to propose using roughly 5 million of that to fund some of these issues without having to continue to increase our fee request. We do have flexibility, if you remember from last year, in statute if we didn't sell the building, we were able to use CSF funds for general fund. And so we would be asking the legislature to extend that flexibility for an additional year, or at least to allow us to make this one-time use of 5 million of that, those funds in the CSF reserve. So that's one of them. The second one, and kind of relatedly, would be a clarification that any money that we collect on CSF reimbursements, once an attorney has, once the CSF has paid out a client because of attorney wrongdoing, the attorney is ordered to reimburse the CSF fund. And so when we are engaging in collections activity, if we recover some of those fees from attorneys, we would like the flexibility to be able to use that in the general fund instead of going back into CSF. And then the final one has, along the lines of collections, it involves amending our CSF statute at 6140.5 to have the flexibility to negotiate a settlement, if you will, with attorneys as we're trying to collect those funds in order for them to be reinstated. So this would give us the flexibility to reduce the interest or the principal and land on some kind of settlement that the attorney could pay so they could be reinstated. We have a similar provision in the statute that allows us to collect on attorney cost, disciplinary costs. And so we would just propose that we mirror that language into the CSF statute. So those are the three main items that we're proposing.
And just for further clarification, the second proposal that Bridget had mentioned that would permit us to use collections related to the CSF reimbursement for IT expenses and other operational needs. This is attributable to the fact that as we were looking at the chart before, we saw the legislature underfunded the $20 million ongoing structural deficit, underfunded the lease costs specifically, and this having access to this these collections, being able to apply that to address some of the underfunding would be critical for us going forward. And with that, I think we're happy to take any questions.
Thank you so much. I see a question from Jose.
Thank you, Chair. And I want to appreciate the staff's work on this, and I particularly want to relate the great work that you, Chair, and our Executive Director Leah did in the hearing that we had in person in Sacramento. I am encouraged by the conversations that staff is reporting that we're having with the members of the legislature. And I think that our ability to undergo a conversation with them where not only are they open to at least some of the funding that we were requesting, they seem to be still open to discussing the possibility that even more than they initially proposed would be worth considering, also including being included in the fee bill, ultimately drafted fee bill. Of course, and I'm sure many of us are disappointed they couldn't fund the entire ask we made, because I know we made it very carefully, thoughtfully, and correctly in terms of what we know we need to, for example, keep the lights on, and also to cover some other important initiatives. So I would just, in reaction to your question, Donna, about what position do we take right now, given that our current position, I believe you said, is support if amended to cover the entire $125 ask. I would imagine that since we're still in conversations with them and they seem open to moving off of their initial number, I think that we might consider leaving that statement as is, not touching it, while our conversations go on. And we're both, it sounds like, in dialogue and being very open and communicative, that we're still willing to consider a compromise number. But until we've reached that mutually agreed upon compromise number, it seems a little premature to change our statement. That's my thought. Thanks, Chair.
Thank you, Vice Chair Saros. All right, any other questions or comments?
This is Arnie. Just real quick.
Donna, have we had some conversations with staff about the ERA system already?
We have not. We sent that information over this week, and we are anticipating having potentially addressing, sort of preliminarily addressing that issue tomorrow, and then in further conversations over the next couple of weeks. We did talk with the legislature. I mean, this was detailed, I think, in the justification for fee increase report. We did talk with the legislature back in 2019 about the ERA system and wanting to secure funding for that. The legislature provided us at the time with $3.5 million. Subsequently, and I recall Leah going into some depth in this in our last board meeting, we got some bids for $10 million plus, and realized that we obviously didn't have anywhere near sufficient funding for that. We utilized the $3.5 million for sort of fixes and plugging holes and doing things that we needed to do to keep the existing system operating, but we were not able to get a new system. We have subsequently, started looking into off-the-shelf products and things that we could do for considerably less money.
All right, thank you. Anybody else? I'll just echo some of what Vice Chair Cisneros and Donna talked about regarding communications with the legislature. And I think that there's certainly a change in what I'm hearing from legislature, especially in contrast to the joint hearing. I think the joint hearing, there are very clear expectations that were laid out for the bar, things that we needed to do in order to get our house in order. And all of those things for us to get our house in order take staff time, they take resources. The programs that have been rolled out, particularly the Client Trust Account Protection Program, has been very successful, and has, I think, really helped to instill the public's confidence in lawyers and to rebuild that trust. When it comes down to it, all those things cost money. The bar overall, I think, has really made great strides to continue to rebuild the trust in the legislature and the public. As to the number that I believe that we should continue to advocate for, I don't see a change in circumstance as far as our needs go. I think we can continue to make that case, and that we continue to meet with various legislators and with the committees to make that need known. I know that each trustee here has an interest in making sure that the state bar is the best organization it can be, and so definitely be leaning heavily on each individual trustee to help make that a reality, because the the costs or the end result of this conversation is whether or not we have enough money to keep the lights on, or if we have enough money to fulfill our contractual obligations. Not only that, but to really expand on these public protection programs that we believe in and that the legislature believes in. So I think if we can't get to that 125 mark, there is going to be a drop off in services. There's going to be a very real impact. That's something that I tried to communicate at the Assembly Judiciary hearing meeting, and will continue to address in conversations going forward. So I for one am comfortable continuing to advocate for the 125 because I believe it's based on our very real needs.
If I can add, Mr. Chair, as I mentioned, the amount that the legislature has authorized, even as we have sort of given them what would be the adjusted number if they agree to that, that would take us to a 15% vacancy rate. And certainly at the leadership of the bar feels that our commitment to our staff is not only to meet the COLAs and the merit increases, but a commitment to them sort of as a whole person, and the morale issues that are going to happen if we go to a 15% vacancy rate, the extraordinary changes in workload that could happen if expectations are not modified. And there are certainly areas such as the Office of Chief Trial Counsel that don't have control over the number of things that come in the door. And regardless of what we do, they're still going to be receiving 15 to 18,000 complaints every year. And if they have a significantly higher vacancy rate, significantly fewer staff that have to process those cases, even if the expectations are different, there can be some overwhelming caseloads that folks would have to deal with. And so at a staff leadership perspective, we really do, I think, value continuing the full request so that we really can look out fully for our staff and not just though of course we recognize the importance of the negotiated increases, but really look at them sort of as whole people.
Absolutely. No, thank you, Donna, for bringing that up. That is absolutely a core concern. I know for myself, and I know certainly it's echoed with other trustees. Are there any other questions or comments? And if not, can I have a resolution? I'm sorry, once the resolution's up, I can't see if someone raises their hand. So if you have raised your hand, just go ahead and speak.
And we've added a resolution while we were talking here, specifically the bottom resolution that directs that we continue our support of the bill if amended to provide $125 licensing fee increase.
Great, thank you. That does clarify it.
I think there's just a typo in the last paragraph. Include provide.
I was typing very quickly while you all were talking.
No worries.
Take out the provide, Tinny, if you would.
We get paid by the word, so there goes a couple more. All right. If everybody's had a chance to read through that, can I have a motion?
Brandon, I'll make the motion.
All right, first by Vice Chair Cisneros. Is there a second?
This is Arnie, I'll second.
Second by Trustee Sewell. Louisa, can we have a roll call vote, please?
Barahona.
Aye.
Buenaventura.
Aye.
Chen, not present. Cisneros.
Aye.
Good.
Aye.
Huser.
Aye.
Shelby.
Nay.
Stevens.
Aye.
Sewell.
Aye.
Tony, not present. Trejo.
Yes.
Stallings.
Aye.
It's 9 ayes, 1 no, motion carries.
All right. Thank you to staff and thank you to our employees who are tracking this for obvious reasons. We do greatly appreciate your service here at the State Bar and appreciate the hard work that you put in to protect the members of the public. So thank you for your concern in this, and we look forward to continued communications with you. Moving on to item 703, this is the 2022 to 2027 strategic plan review and approval of new goal 5. And this will be presented by Elizabeth Nolan.
Good afternoon. Can you hear me?
We can. Welcome.
Thank you. There is a slide deck that goes with this, so I will go ahead and share.
Elizabeth, do you want me to share?
I can share it, Lisa. I think it's fine.
Oh, I was going to share directly from Disney, but that's okay.
Okay.
Just,
yeah, if you want to share that section.
Can everyone see my screen okay?
Yes.
Okay. Good afternoon, trustees. I'm presenting on proposed modifications to the State Bar strategic plan, which reflect revisions to the proposed Goal 5 on information technology. So as a reminder, during the March Board of Trustees meeting, the board approved staff recommended changes only to goals 1 through 4 of the strategic plan, which allowed for condensation of several implementation steps to reduce redundancy in language. The board also considered adding a Goal 5 and reviewed draft language for that goal. Trustees raised concerns during that meeting about the draft language, specifically the language on artificial intelligence and cybersecurity, and directed staff to work with designated board members to finalize Goal 5 language. Staff met with the board members to revise language in April. Next slide, please. Staff recommends that the board adopt Goal 5 with the revisions that I'll discuss shortly. So all goals in the strategic plan currently contain a goal statement, a vision statement, a set of strategies, and a set of implementation steps that underlie the strategies. Adding Goal 5 would increase the overall number of implementation steps in the strategic plan to 58. This is the updated goal statement and vision language. The yellow text reflects changes since the March board meeting. Staff believe that this language better reflects the State Bar's commitment to investment in IT security and infrastructure. Also, given the State Bar's intent to responsibly use artificial intelligence tools to enhance its operations, that language is reflected in the vision statement. Next slide. This slide reflects the State Bar strategy statements, which very simply are statements that reflect the broad approach the State Bar will take to achieve its goal and vision in the areas of effectiveness, consumer focus, diversity, equity, and inclusion, and policy and systems change. Next slide. I want to spend a few minutes walking through the implementation step language, since this is the language that primarily guides operational activities and State Bar staff work. Under effectiveness, the implementation steps relate to assessing existing IT systems and infrastructure to understand whether and where infrastructure gaps occur and to ensure strong, dependable IT infrastructure foundations. Next slide. Under consumer focus, staff emphasize the importance of better serving the public using IT and data governance frameworks. In order to best serve the public, there's a need to implement a consistent and robust data governance framework, which refers to a set of formal policies and practices designed to ensure the effective management of data within an organization. Next slide. Under diversity, equity, and inclusion, staff aim to ensure data and IT systems, whether used internally or used by the public, are implemented with inclusion and accessibility in mind. Next slide. And this is the final one. Under policy and systems change, you'll find an emphasis on not only securing appropriate funding levels for IT, but an emphasis on robust and consistent fiscal oversight of IT expenditures. The last implementation step here focuses on developing robust guardrails for artificial intelligence use. I want to point out here that there's a longer-term plan to enhance these artificial intelligence guardrails at the State Bar, as recommended by trustees during the March meeting. I believe future agenda items are planned so that the board may review those artificial intelligence guardrails in draft form. I'm happy to take any questions.
All right, thank you, Ms. Nolan. Any questions? All right, any comments? Trustee Trejo.
I just want to say that I appreciate you going into the detail on this item. I think that's obviously a very big one, and it could be a little overwhelming and even sometimes nebulous. So I certainly appreciate the approach and the attempt to find a solution. So thank you.
All right, if there are no other comments or questions, can we have the resolution put up on the screen? Once you've had a chance to review the resolution, I have a motion in a second.
So moved.
I'm sorry, I couldn't see who that was. Who made the first?
Trustee Barahona.
All right, thank you. Is there a second?
Second.
All right, I think that was Trustee Sewell.
That was Trustee Stevens.
Stevens, sorry.
Yes.
And again, when the resolutions are up, the device I'm on doesn't show everybody, so I do apologize. All right, first and a second. Madam Secretary, can I have a roll call vote, please?
Sure. Barahona.
Aye.
Buenaventura.
Aye.
Chen, not present. Cisneros.
Aye.
Good.
Aye.
Huser.
Aye.
Shelby.
Aye.
Stevens.
Aye.
Soel.
Aye.
Tony. Not present. Trejo.
Aye.
And Stallings.
Aye.
That's 10 ayes, 0 nays, motion carries.
All right, thank you to staff for taking on this new strategic plan. I think it's absolutely vital to our organization and the future of it. And I also do thank the trustees who engaged in the artificial intelligence component. So I know that everybody here is working a lot and appreciate the time and effort involved. Moving on to item 704, adoption of state bar policy on law school name changes on the attorney profile. This item is being presented by Special Counsel Steve Moawad and Deputy Special Counsel Mia Ellis. So welcome back, both of you.
Thank you, Mr. Chair. Good afternoon, members of the board. The State Bar proposes adoption of a new formal policy regarding law school name changes as they are displayed on the attorney profile page. We've determined that this is necessary as the State Bar historically has applied different practices when a law school changes its name. The proposal is that the law school name changes will only apply prospectively, so only affecting graduates after the effective date of the school's name change. Staff did initiate a public comment process for the proposal. Public feedback showed over 60% in agreement with the proposal. There were about 20% who disagreed with the proposal as presented. Some of just very briefly, some expressed support for changing a law school's name for social justice reasons. Other commenters suggested as a compromise adding the current and former name of the law school to the profile page. Some express giving graduates a choice of what the name that appears on the public profile page. And then some also express they did not think that the law school name change on the profile page should be applied retroactively, which for us suggested that they may have conflated the prior proposal or practice with our current proposal. I will just highlight that the proposed policy sent out for public comment included a provision that retroactive application of the name change on the attorney profile page would be required where the law school issues new diplomas. But because we cannot confirm if new diplomas are issued, the current State Bar proposal does not include that language. So this item, again, requests board approval of a modified proposal reflecting the feedback we've received so far. I'm happy to take any questions.
All right, thank you. Any questions? All right, if there's no questions or comments, now I have a motion. All right, if everybody's had a chance to review the resolution, may I have a motion?
It's Jose, I'll make the motion.
Thank you. First by Vice Chair Cisneros. Is there a second?
Second.
All right, second by Trustee Stevens. Louisa, can I have a roll call vote, please?
Barahona,
Aye.
Buenaventura,
Aye.
Chen, not present, Cisneros,
Aye.
Good,
Nay.
Huser,
Aye.
Shelby, Stevens,
Aye.
Soel,
Aye.
Tony, not present, Trejo,
Aye.
Stallings.
Aye.
That's 9 ayes, 1 nay. Motion carries.
All right, thank you to staff for your work on this. Appreciate it. Our last agenda item is item 705. It's approval of our 2024 Q1 financial statements report. And this is being presented on by our Chief Financial Officer, Araceli Montoya-Chico. So welcome back. And I'm glad that we saved the numbers for the last. I'm sure the numbers will really track with us after a fun day.
Save the best for last. So
Exactly.
I'm the last agenda item, I believe, before your day's over. So I do have just a couple of slides to share, to present, excuse me. So I will share my screen, and if you could please let me know once you see it.
Yep, see it.
Good. Okay, great. So I'm going to be presenting the results for the Q1 2024 financial statements. I will first start going through the revenue results, highlighting some of the variance reasons, and then I'll move on to the expenses. So first off, our operating revenue as of Q1 ending March 31st is about 184 million. That's almost $10 million over budget, and that's bar wide. And the composition at the fund level is listed here below. So first off, starting with the general fund, overall, the general fund is slightly above budget by just under $1 million. And that's really mainly due to the late fees from the CTAP program. It's the second year of the program, and we've had still attorneys, late compliance of attorneys. So we earn late fees on that. One of the things I wanted to highlight is our mandatory fees are likely to fall short of our annual budget target so far. So in Q1, or we typically receive about 97 to 98% of the general fund's mandatory revenue during billing season, which occurs in Q1. So far, to meet our annual target, we need to collect about $3.7 million more to reach that annual budget. And historically, we haven't collected that much money. That's close to $4 million that we just historically have not collected in the remaining 9 months. So I just wanted to bring that point to light, that we probably will fall short of our mandatory fee revenues. We have had some issues with IT challenges in the CTAP program. So there's about just under 2,000 attorneys that are unpaid at this point in time versus prior years. So we might make up some of that shortfall, but we don't believe it's going to be enough to bridge the necessary gap to meet our budgeted needs. Obviously, I do have hopes that in other areas such as late fees or even investment income, that we can earn more from those revenues to make up whatever shortfall we probably will experience in mandatory fees. So I did wanted to bring that point. Obviously, we will keep monitoring things in Q2 to see how many more attorneys have possibly paid and if we have more late fees. And we will keep assessing if we need to revise our revenue projections at the mid-year. Moving on to the Equal Access Fund, that's also under budget, below budget by close to 700,000. And that's really just mostly due to return grant funds from prior year and grant administrative reimbursements that are a result of delayed billing. So they should catch up as the year goes on, but those are some of the reasons for the shortfall in the Equal Access Fund. And just as a reminder, all the grant-related funds, which is Equal Access Fund, Grants Fund, and the Legal Services Trust Fund. Those are all mostly pass-through funds, grant funds. You'll see the same on the expenses, and only a portion really we get to keep. And those are what we're calling these grant administrative cost reimbursements. Really quick on the grants fund, it's slightly below budget, only about 300,000. And again, that's really just due to reduced billable time and delayed billings to get those grant administrative reimbursements in. So it should correct going forward as the year goes on. Legal Services Trust Fund, you see that it's well above our revenue targets, almost $10 million above. And this is a continued variance that we keep seeing in the Legal Services Trust Fund. We had originally budgeted close to $4.4 billion, but the actual account balances is close to, it's actually about 5.4. So the actuals are significantly above budget. So that's really causing a lot of interest earning on almost $1 billion over from our budget. So you will continue to see this trend going forward in the Legal Services Trust Fund. In the admissions fund, it's actually the revenues are slightly above budget by about 700,000, and that's primarily due to more applicants that register for the July bar exam, which is good. The February bar exam only had a small variance of about $100,000 over budget. So that's the admissions fund. And then finally, the other funds, it's above budget by about just under $500,000. And that's really just mainly due to Justice Gap donations that are a result from settlements. Moving on to the expenses, bar-wide, we are about $84 million, which is $9.6 million under budget. And this is the makeup of that variance at the fund level. Starting first with the general fund, we are below budget, mainly due to personnel savings, service savings, and IT expenditures. On the personnel side, it's really a big reason is because we have accruals that we make at year end that get reversed in Q1. So it's a negative, it's an offset to expenses because of those accrual reversals, but that'll self-correct as the year goes on and we record more expenses. Services and IT expenditures, there tends to be more expenditures in the later half of the year when it comes to IT expenditures and services. So for Q1, it looks like we have less expenses, but as the year does progress, we should be seeing an increase in expenses. Moving on to the Equal Access Fund, similar to how you explained on the revenue side, it's lower than budget due to the prior year return funds and also timing of invoice submissions. The admissions fund is also slightly below budget by close to $2 million. And again, that's due to the timing of greater proctors and certain professional service invoice submissions. A lot of our expenditures in Q1 tend to be at timing of invoice submissions. If we don't get the invoices in on time, they get recorded in subsequent months. So obviously, as the year progresses, the expenses get closer to our budgets. Finally, in the other funds, that is also under budget by about $2.4 million. And this is really a result of a budgeting error. We were provided in the bank settlement fund, we were provided disbursements in the bank settlement fund that were covering 2 years instead of 1. So we will correct that at the mid-year to make sure that it only covers 1 year and not 2. Otherwise, that's the results for the quarter. If anybody has any questions, happy to answer.
All right, thank you so much. Any questions for our Chief Financial Officer? Okay, any comments? Right.
Thank you for always being so clear and thorough with your quarterly updates. I think the lack of questions is just a reflection of how you always present so well to us. So thank you.
Thank you, Melanie. Appreciate that.
Well, with that comment in mind, could we put the resolution up, please? After everybody's had a chance to review, I'm gonna have a first and a second.
Move to approve.
First by Trustee Stevens. Do I have a second?
I'll second. This is Arnie.
Second by Trustee Sewell. Madam Secretary, can I have a roll call vote, please? Oh, you're on mute.
Sorry. Maybe that's
Go
why.
ahead.
Barahona,
Aye.
thank you. Buenaventura,
Aye.
Chen, not present. Cisneros,
Aye.
Good,
Aye.
Huser,
Aye.
Shelby,
Aye.
Stevens,
Aye.
Soel,
Aye.
Tony,
Aye.
Trejo,
Aye.
and Stallings.
Aye.
It's 11 ayes, 0 nays, motion carries.
All right. Thank you so much, Ms. Montoya-Chico. Appreciate everything. All right, that concludes our agenda. And it's 4:05, so hopefully you have tomorrow blacked out and you can enjoy it or get caught up on work. So thank you to staff for making this meeting go exceptionally smoothly. And thank you so much for your continued work as we grapple with these big issues. So we will see you sooner rather than later. So please keep your eyes open for the poll regarding a special meeting coming up here. All right, with that, meeting adjourned.
Thank you all.
Good to see you.
Thank you.